teach a lot of common law stuff in political science department. It's weird because I don't really know that world. Like, I don't know, like, oh, that's my book, yeah.
Yeah, I read it.
Which is actually something that I'm actually thinking about revising. It is so dated in terms of my defense of a kind of Christian view of liberalism that nobody's a liberal anymore. I mean, in a sort of traditional sense. What? Yeah, I mean, it's wild how it's like,
Okay.
you know, whether it's the right or the left, there's this movement away from that kind of older way of thinking about disagreement. But, I haven't been back to Summit since before COVID, because that was summer of 2019. And so then in 2020 they had this weird kind of hybrid, and then actually last year they did it.
Canceled.
Some of the people in the back might leave early.
That's great. Yeah, I did. I stepped in for him here. They actually rented property here. Yeah. And I said, look, I'm around.
Maybe he can announce that if people have to leave early, they should leave out the back door. Because some of my students may be coming in late. I know, so I already
don't know
told
whether,
them.
is that door open?
Well, it should definitely be open for them to
It used to
exit.
be, I mean, when I first began,
Richard.
25 years until
Sorry.
1996, there was
I
no
know you're not
competition, and then all of a
Maybe
sudden now there's all
you can
these
make an announcement that if people
summer
have to leave early,
options,
that
not
they
only
exit out the rear
camps, but
doors.
you've got things like the
Because it's a long
Witherspoon
time to be here, and
Institute
people start leaving, it gets really disruptive.
I think even the religious freedom folks, Tom Farr's
That's all
group
right.
has something for
If not, we'll just live with a
it's
lot of
like
banging.
everywhere.
Okay. All right.
Which is good. Keeps the dialogue going.
Good afternoon, everybody. Is this thing working? Sounds like it. Eh? I'm gonna have to stand a lot closer, it seems, because there we go. I think that's a little better. Excellent. Well, we're back, right? It's been a crazy couple of years for all of us, filled with far too many hardships for us. So we're all very grateful that you're able to make it out, and we're happy to be here to engage with each other once again. Thank you for being here while we try and tackle this very important issue. Before we begin, I would like to express our gratitude and give thanks to everybody that makes this presentation possible. Thank you to our esteemed president, Dr. Teresa Leba Ruiz, and thank you to our vice president of academic affairs, Scott Schultz. Both have always encouraged philosophical discourse on our campus, and we appreciate it quite a bit. Thank you to Connie Greenwell and Lena Farisi for helping us organize our panel and to bring in Dr. Beckwith to speak with us today. A special thank you to the marketing team, to our media department, and of course to our facilities. We could not do any of this without you, and so we appreciate you guys immensely. I thank you to the Philosophy and Religious Studies Department, including the Philosophy Club, for putting this on. That is absolutely a shameless self-promotion, so. If you didn't know we have a Philosophy Club on campus, come join us at Fridays at 1 underneath the Tree of Wisdom. Now, it is our great honor to welcome each of the panel members who have joined us today, especially our guests from outside the college, Dr. Francis Beckwith from Baylor University and Dr. Jeffrey Ventrella from the Alliance Defending Freedom. Dr. Beckwith is a professor of philosophy and church-state studies at Baylor University with a long and illustrious career, complete with numerous publications, including books, papers, articles, and the like. He will be providing one side of the philosophical debate in our discussion today. Also, I found out he met the Pope. That's pretty amazing. Dr. Ventrella is a senior counsel and senior vice president of academic affairs for the Alliance Defending Freedom. The ADF is a legal organization specializing in cases revolving around religious freedom and free speech, among others. He will be giving one side of the legal and constitutional aspects of this discussion. Dr. Terry Desai is one of our own, teaching political science in the social sciences department, as well as being an assistant department chair. She'll be providing a defense of the separation of church and state, and naturally, giving us a poli-sci perspective, or the other side of the legal and constitutional perspective. Rounding out our panel is our very own Professor Peter Lupu, the current chair of the Philosophy and Religious Studies Department, as well as the creator and instigator of the Critical Dialogue panel. And he will be giving us, as always, his very unique and particular angle in the philosophical aspect of our debate. So thank you to all the members of the panel for being with us here today. We are deeply grateful to have you here, challenging us and helping us to think in new and interesting ways. We appreciate you taking the time out of your busy schedules to be with us, even more so if Peter has coerced you into being here. I'm sorry, Dr. Desai. And thank you, everyone in the audience, for being here, wanting to learn something new and hear some interesting and challenging perspectives. And thank you to all the professors offering extra credit to actually get your students to show up. We appreciate it. So, today's topic. As you can see, the big panel behind us, it is of deep significance for our culture, having been heavily debated since the founding of our country. As our country has grown and become incredibly diverse, it is only natural that we should continue to revisit our foundational documents and ideals. When dealing with the natural rights of a group of people, there will always be tension between the rights of the individual as they butt up against each other. Often we ask, where do our rights end and yours begin? And a simple answer that's often given is, my right to swing my fist ends where your nose begins. However, when we are discussing abstract ideas that have concrete and sometimes far-reaching consequences, these results, untangling those rights become messy and chaotic. The right to free religious expression is one of those rights that can have messy consequences in a pluralistic society. Each individual has the right to believe as they see fit, and theoretically at least, to practice as they see fit. However, this isn't without limitations and sometimes conflict between groups. If you'll indulge me, I'd like to share a few examples I have found interesting over the years. The first example happened some time ago in New York. There were a situation involving Muslim cab drivers at the JFK airport. Now, if any of you guys have been through JFK, you know that one of the cool things is you can get duty-free alcohol. Oh wait, most of you guys are minors, never mind. Doctrinally, in Islam, it is forbidden not only to consume alcohol, but also to sell it and transport it. So many of the cab drivers would refuse service to those travelers who had alcohol in their person. If the driver refused to give a ride, the policy for cab drivers stated they were supposed to move to the back of the line for the sake of fairness. Now, the drivers argued that they were following the tenets of the religion not to transport alcohol, and to force them to either carry alcohol or compel them to go to the back of the line would actually infringe upon their free religious expression. So, more recently, there have been several famous cases, which some of you are probably familiar with, involving private pharmacies run by devout Christians refusing to offer specific birth control options like the Plan B pill. Other situations we've seen involves the Christian bakers who have refused to bake wedding cakes for gay weddings, most famous example in Colorado. And one final example I'd like to bring up, I always thought this was an interesting example, comes from Florida, because all fun things come from Florida. Now, this actually stemmed from an Appalachian tradition. So there's a small group of devout Christians in the area who believe that they can handle venomous snakes during their church services, citing a passage from the Gospel of Mark. Now, at some point, the state became concerned that these practices, because there were children present and they were considered to be in danger of being bitten, as you might imagine. So the community went to court over the right to express their religious tradition as they saw fit. However, the courts argued against them and ruled, at least in Florida, that they are allowed to keep the snakes. However, the venom sacs have to be removed so they're no longer deadly. Now, these are just a few examples in the history of our country, and clearly there are many more that we could point to, often with far greater consequences, especially those involving religious belief and medical treatments. Many of these cases have gone to various levels of the court system, including the Supreme Court, in an attempt to analyze and clarify the scope and limit of the free expression of religion. Now, as Professor Lupu likes to point out, one of the core issues in a classically liberal and pluralistic society is the tension between the individual and the community. What are the boundaries between individual rights and the common good of everyone? Hopefully, we'll be able to discover a little clarity after today's discussion with that. So, brief mention of the format. Each of the panelists will come up and speak for roughly 20 minutes, giving their presentations. After each of them have presented, there will be about a 20-minute discussion between the four panelists to sort of hash out their ideas. And then after that, we'll have a Q&A session. So once we remark about that, then you guys can line up here behind the microphone to ask your question of the panelists. I was also asked to remind you, I know this is a very long thing, and some of you have classes you have to get to that you can't ditch from. I appreciate that. When you have to leave, we ask that you leave through the back to try and be just a little less distracting, but I know that you have to go. So anyway, thank you very much, and I hope we have an excellent time. Also, I do believe that we decided we're going to go in order of the list. So Dr. Jeffrey Ventrella, we welcome you. Thank you very much.
Well, thank you so much. I really appreciate that. And of all the introductions I've had, that is certainly the most recent. What I'm going to be addressing today is this notion of being legally human. Is law for man, or is man for law? Now, it's a bit odd how I came to be with you today. I was talking to my longtime friend, Richard, and he said, now you have a PhD, but you're still a lawyer, right? I go, yeah. He said, do you believe in the Constitution? I said, yes. He said, do you believe in the First Amendment? I said, yes. He said, well, do you believe in free speech? I said, well, of course I believe in free speech. He said, good, I want you to give one at Glendale Community College. So let me start with a question that I think really shapes this issue. Did people possess a right to free speech and expression of religious practices prior to 1791? And if so, why? And that's what I want to unfold as we set the table for today's discussion. Now, what's this? Audience participation. Can you see this? It's a pen. Are you sure? Pretty sure. Pretty sure. What if I do this? It's a comb, not a pen. You're all wrong. What's the point? That's kind of a cringy way of illustrating something. There's a key distinction between what X does and what X is for. Query, which one ought to have the priority? What it can do, that universe, or what it's designed to do? I want to suggest that to understand our topic today, there's some key foundational questions. What is mankind for, and what is the law for? Those two need to cohere, and we need to answer them correctly. And to be legally responsible in understanding the scope and the limits of the First Amendment, we must identify, reaffirm, and in fact obey a proper understanding of ethics, reality, including the reality of humankind. Well, what comprises that particular reality? How do we affirm it and act responsible in terms of that? These are really worldview questions that will drive our analysis of the text of the First Amendment. So first, what is mankind? You know, as to human rights, there's many popular expressions in today's world, in law and in society, and particularly the positive law, that is to say, the man-made enacted law. We have charters of rights. We have bills of rights. We have covenants and conventions of rights. We even have a universal declaration of human rights. And yet, in spite of all those, shall we call them, parchment rights, well-intended positive law, we are still actually seeing an increase of the persecution of Christians and other religious adherents. We're seeing an increase in the censorship of speech, including religious speech, the crushing of dissent. We're seeing financial hardships imposed via deplatforming or canceling. Whatever you think of what's going on in Canada, you're seeing entire monetary systems being shut down. We're seeing the destruction of the weakest, including unborn life. We're seeing the malformation of holy matrimony. We're seeing sexual expressionism and the anarchy that results from it. We're seeing a denial of parental authorities in a myriad of ways, both in medicine and in religious upbringing. We're seeing gender ideology that, frankly, in many cases, renders children mutilated and or sterile. We're seeing cancel culture over and over. These are just symptoms of what's going on. I think we need to understand a solution requires us to unearth foundational points. Let me put it this way. Until we get human right, we're not going to get human rights right. And until we do those two things, we're not going to have the right law and understand what the law is designed to do. So what is it that we know, or if that seems too bold, what is it that we presuppose when it comes to this notion of humans interacting with law? I submit there's at least two things. One is that human beings are a kind of thing that has a nature. Number two, that particular being has an inherent dignity. There is a foundational ontological equality of all humans. Now, without those presuppositions, law and social order would be certainly arbitrary, or if not flatly catastrophic. And interestingly, my claim would be that it is the Christian conception of humanity, not the Enlightenment thread, not secularist predicates, but the Christian foundation that actually provides a workable, justifiable foundation for both nature and dignity that law must presuppose. And that predicate is certainly for a Western conception of human flourishing, and I would argue a global conception of human flourishing. And I base that, I happen to be a professing Christian, but you also will find this in a number of non-Christian authors and scholars. Larry Siedentop at Oxford, Tom Holland from the UK, Luke Ferry, the philosopher in Paris, Stephen Smith, the law professor in San Diego. I'm not going to go into that, but distilled to their essence, they will tell you a number of things. One, to be human is to understand it's a finite creature. That is to say, it's a created creature. And thus, as a creature, there is a fundamental creator-creature distinction. Mankind is dependent as to his ontology and is also not autonomous as to his morality. Second of all, mankind consists of an inherent integrated nature. Humans do not have bodies. Humans are embodied beings. There's a corporal and non-corporeal unity, material and immaterial. Now, why is that important? Because that's contrary to Gnostic dualism, which is a driving force of gender ideology. It's contrary to materialistic monism, which is Marxism and all the rest. It's contrary to pantheistic monism, which is, some people might call it New Age. There's a fixed and a universal nature that allows for this justification under law to treat people equally. This is where we get that business of the consent of the governed. Why would that matter? Because there's a foundational ontological equality. And that applies whether one has a particular religious tradition or ritual or not. What are the implications then? Well, there's always going to be a law above the law. There's always going to be some transcendent standard by which we adjudicate particular expressions of the positive law. We saw this early on when Ambrose stood against the Emperor Theodosius. He did some really bad stuff, and he had to be accountable for that. Second of all, authority is always going to be a derivative sort of authority. That is to say, there's going to be a limitation of the state and hence the positive law's power. We saw this, of course, in the United States a century and a half ago. Slavery was legal. Segregation was legal. But there was a higher principle, a higher law that allowed us to correct those injustices. And then, of course, there's this notion that the law must be applied equally. No favoritism, no partiality. Justice must be blind. And we see this articulated so well by Dr. Martin Luther King Jr. The third point, I would argue, would be that there's a human exceptionalism in this particular model. There's a number of implications here, but mankind is in fact a social creature, contrary to libertarianism, and that has implications for law. Second, mankind is rational, contrary to some post-modernity concepts. That is to say, we are designed to make distinctions, to have dialogues, to reason, to communicate, and so forth. Well, that's pretty important. If you look at Amanda Cottrell's new book called Cultish, whenever you fill in a blank and just label somebody, it stifles not only discussion, it stifles thinking. We're not designed to do that. We're not designed to shut people down by saying, you're ex-phobic, that sort of stuff. That's contrary to the nature of the human person. You know, and also there's a notion that the public square cannot, in fact, be neutral. Where John Rawls would argue that, we have to get rid of overarching narratives. Well, except for that one, apparently. Well, that's just not going to cut mustard with respect to the nature of the human person. I would also argue that mankind is inherently a worshiper of something, that we are designed, in fact, to be provoked to a worship response. And so to say, come to the public square, but jettison your religious presuppositions or your religious expression is to essentially say, come to the public square and cease being human. Amputate that part of your inherent human nature. And then, of course, we're here for a purpose. We're here to do something other than take up space and consume oxygen. Now, there's also a notion, and this we're not probably going to get into this, but just to round out the thinking here, is that there's a metaphysical reality of maleness and femaleness. Law applies to ethics, not metaphysics. And so we start this business when the law starts claiming that we can move people around metaphysically. That should be a signal to ask some really tough kinds of questions. Okay, so that's what is mankind. Well, then what is law? Let me give you some preliminary considerations here. First, the state, as we understand it, is a creator and administrator of the positive law. No objection there. But how then do we conceive the role of the state? Is that of a servant or of a savior? That becomes pretty important when we start to exegete the First Amendment and apply it. Second of all, preliminarily, what's the jurisdiction of the state? What should it be? Is it totalistic? That is to say, does it reach all of human experience, including the nooks and crannies between our ears, telling us what to think and what to say? The Supreme Court just today granted certiorari in one of our clients' cases that will be dealing with this notion of compelled speech. That's kind of important. Or is it the jurisdiction of the state to protect, negatively protect pre-political rights, those rights which existed before 1791? Second of all, is the jurisdiction of the state autonomous and therefore self-creating, self-legislating, or is it subject to some other external considerations to it, such as perhaps the consent of the people or even a higher standard? And thirdly, is the state absolute, or is it answerable to a different authority? Now, none of these first attributes that I mentioned would cohere with what Martin Luther King Jr. set forth in the letter from Birmingham jail and other places. So then we get to a provocative question by Douglas Farrow. He's at McGill in Montreal, and I think it helps us focus. Are we really to suppose that the state, and by implication the state's legal system, functions best when it concerns itself as little as possible with what is actually right or wrong, actually good or evil, actually conducive to happiness or unhappiness? And by that he means human flourishing. So I think those are important questions to ask. We can't just hop skip over them. So then we get to the question of what about ordered liberty? How do we deal with this? Well, we see again from a religious tradition, what was the Exodus? Well, the Exodus was when there was a people that were enslaved, the Hebrews, that were liberated. And what do we see upon their liberation? The giving of the Decalogue, the 10 words. We know them as the 10 Commandments. So in other words, law was given to order and structure a people so that they could flourish, so that they could be people who would do their utmost with respect to that. We see this then applied by Jesus Christ in Mark chapter 2, where he talks about the Sabbath day, one of the 10 Commandments. And what does he say? The Sabbath was made for man, not man for the Sabbath, which gets to my title of my presentation, my remarks today. What's the nature of the human being? Is the human being subject to the law for the sake of the law, or is the law serving some purpose that's tethered to the design, the telos, the aim of what it means to be human? Well, what's interesting is that the early Christian believers, my PhD is in church-state studies, so I'm going to kind of camp out there. But the early Christian people understood this, and they culturally applied their religious convictions in the public square. What did they face in the first and second Roman century? They faced chattel slavery, they faced gladiatorial combat, and they faced infanticide through infant exposure. Those, I think, unless you're some type of sadist, people would say, we need to get rid of those things. They got rid of them not only for motivation, but by making philosophical arguments predicated upon their religious convictions. They exposed these evil things in culture, they opposed these evil things in the culture, and then they foreclosed them, ultimately by law serving the condition of humanity. We see at the same time, though, the early church writers articulating justifications for religious liberty. Tertullian is an early example. He was a lawyer as well as an early church father. He's the one who created the term religious liberty. We see Lactantius, who did the same thing. This idea that, wait a minute, because of the nature of the human person, you must not coerce conversion or certainly not belief. That simply cannot exist. And that was when the Christians were a minority, or when they in fact began to assume political power just by sheer population. Non-coercion was the rule. Footnote, Augustine got this point wrong. He's really good. People still read him. They should, but he was wrong on that point. But for example, by the time you get to the 7th century, you get the Justinian Code, which forbade as a matter of positive law coercion as to what it called the Jews or the pagans. You may not do that because it contradicts the nature of the human person. A person has the right to pursue truth as his conscience conceives of it within the notion of ordered liberty. Now, compare the competing worldviews at the time. You know, Aristotle, pretty smart guy, but he also said that some men were created to be slaves. That was their nature. It's not really a good look. That's a bad optic. Or later on, of course, you see Hegel, the historicist thinkers, that it's just whatever happens, happens. We don't really have an ability to deal with it, and that's simplistic. I realize I've got some philosophers to my left. Rousseau and his progeny, the notion that we're going to force people to be free, that sort of thing, that's not pretty good. So that leads us then to how do we get to the gist of this whole First Amendment deal? And we'll be able to cover this in our discussion. And I have a number of questions I'm looking forward to asking our folks on the other side of this question that deal with this whole separationist notion. But for right now, you need to grapple with this question. Did people have the right to free speech before 1791? Did people possess a right of religious expression or exercise before 1791? Did people possess a right to equal treatment before 1868 and the Civil War amendments? Well, these kinds of rights are pre-political. They're fundamental and they're inherent to the human person, irrespective of the positive law at the time. And this is precisely what the Declaration of Independence was calling out. Jefferson makes it what? He talks about this. People are created equally, and that to secure, not confer, not to offer, but to secure these rights, governments are instituted among men. Notice the polity comes after these rights are acknowledged. And so on and so forth, by the consent of the governed, again reflecting that equality component. If men are created, if they are equal, then the consent of the governed follows naturally, because no person can have authority over another but for consent. So we end up with the American constitutional experiment. Right off the bat, Federalist, which was the ratifying political document. Federalist number 1, what does Hamilton say? Hamilton being not the musical, but the actual person, Alexander. He says, we can create governance, and the history of the world is by governance through accident and force. His near referent there was the French Revolution with the blood flowing and Robespierre and all that business. He says, it's either going to be accident and force or through reflection and reason, or choice is the word he used. He was intending reason. In other words, are we going to have a government that actually optimizes the nature of the human person as a reflective image bearer who has equality and can think? And that was the whole point. As one man then commented, that he says, you know, God's not in the Constitution. The Constitution is in God. The point being that the very strong classical liberal condition, yes, there were other tributaries there, no question about that, but generally speaking, it was this ethos that kept germinating imperfectly at times, particularly in the medieval era, that allowed for this notion of freedom predicated upon the equal dignity and inherent dignity. And that was certainly the aspiration that happened. Did they always practice it well? No, obviously not. But then we get to the First Amendment. What is that business about? Certainly not part of the original Constitution. But the First Amendment has a number of freedoms that are protected, but we're talking about religion here. Well, it was contrary to religious establishmentism, right? Contrary to having the Church of England. There was not going to be this potentially ecclesiocratic or theocratic notion. That was rejected from the notion of a federal institution. But at the same time, it was not designed to cabin or to ban or to bar religious expression or exercise. It was dealing with the establishment of an institutional church, which is different from religion and expression of the people. And so it protected explicitly, it's called out for explicit protection, religious exercise, by implication, religious speech and expression, religious assembly as well, because there's a right to assemble, which is a religious association. Luke Sheehan's scholarship is excellent on this. And there's a dimension there that's implicit that deals not only with the individual, but with the collective. If you put together expression, if you put together association and assembly, it seems that these rights are not only a constellation of individuals together, but actually exist in a corporate dimension of those sorts of things. Moreover, we see in the Federalist Papers a recognition of humankind's finitude and fallenness. And so we need to say, let's not have concentrations of powers. Let's dissipate powers. Let's let people percolate and team and dialogue and debate. Let's multiply factions, which is what Madison said. The guy on my tie, that's James Madison. It's all good. And so with respect to that, we have a feature that is designed to aspire to the highest goods, but not utopia, because it says we're going to form a more perfect union. It's not going to be utopian, as in things like Marxism, neo-Marxism, those sorts of things. Not at all. It's saying, no, this is, we're going to do it. This is the aspiration. This is how we work together. Every person has inherent dignity, and we need to work to those ends. The First Amendment, the text of the First Amendment, properly understood, bolsters and protects that. That law serves humanity. Humanity is not to serve that law. I look forward to our dialogue and interactions, and I've got a lot to say on the separationist theorem. Thank you for your kind attention.
Good afternoon, everybody. Hope you're doing well. The title of my presentation is Religious Speech Special? A lot of what I'm going to, I've actually never given this talk before. It's the result of my work last semester. Baylor gave me a research leave, and I've been thinking about this question about why is it that religious speech is sort of singled out in terms of the way in which we think of it, either mostly in terms of what is called the Establishment Clause. So I want to begin with why I think this is an interesting question. So there's a set of cases that the Supreme Court has dealt with involving what is sometimes called viewpoint discrimination. So some of the cases, their names, or some of you may be familiar with them. I know that the panelists no doubt are. One of them is called Widmer versus Vincent, another one Rosenberger versus Virginia, and the other is Lamb's Chapel versus Center Moriches Union Free School District. So to give you kind of a sense of what the Supreme Court was thinking in these cases, so Widmer versus Vincent involved a University of Missouri, Kansas City policy that forbade religious groups from using the facilities of the institution to have church services or worship services or Bible studies. So you could be an official group at the University of Missouri, Kansas City, but you couldn't use the buildings, let's say like the Young Democrats or the Young Republicans or the chess club could use the facilities. Well, they wound up filing a lawsuit, and the Supreme Court said that they don't actually use the term viewpoint discrimination in this case, but they say that once the government has something called a limited public forum. Once it says you can use our facilities to engage in a particular type of activity, it can't start making distinctions based on content. So another case, Rosenberger versus the University of Virginia, that involves a Christian group that was an officially recognized group that put in for reimbursement of their printing costs, and they were denied it because under the policy of the University of Virginia, no monies could be used to support religion, and that was interpreted as supporting religion. What makes the case historically interesting is that the University of Virginia was founded by Thomas Jefferson, who is very well known for being the chief drafter of the Religious Liberty Bill that was in response to a bill that would have used tax dollars to fund or to pay for Christian ministers. And so what happens, the court winds up ruling in a narrow case, 5-4, that the university can't single out religious speech for a particular or special burden. So in this sense, religious speech is perceived as a species of speech. So in a sense, religious speech isn't special. If, let's say, there is a student group that wants to discuss the works of Spinoza or Descartes or Jean-Paul Sartre, they can do so, right, and have their printing costs reimbursed, but the Christian group can't, and the court says that's That's the sort of thing that universities shouldn't be doing, especially public universities. And so here, it's just perceived as a species of speech. The Lamb's Chapel case, a little different, involves a Christian church that wants to rent space at a local school district to show a film that had been produced by Focus on the Family, and the church is denied the use of the school. Why? Because it is a religious group. Again, the Supreme Court says if you would allow a film dealing with the same subject from a non-religious perspective, you're engaged in viewpoint discrimination, therefore it's unconstitutional. And so there's this whole series of cases that the court has dealt with concerning what they call viewpoint discrimination. Once the government allows for or has a limited public forum, that is some space that is accorded for a particular type of discussion, it can't then single out exclusion based on content. But that actually tells us something about religious speech, that it's just not special, right? Religious speech, if you're going to debate, let's say, an issue about the ultimate meaning of life, you may have religious citizens, you may have non-religious citizens, you may have citizens from a variety of different traditions, Buddhists, Hindus, Christians, and so forth. And so in a sense, religion isn't in any way special. On the other hand, there's many cases where the Supreme Court, in fact, treats religion as special, and those tend to be Establishment Clause cases. So you've got the famous school prayer cases, beginning in the early 1960s, and the court winds up ruling against the school districts that allow for what the school districts call voluntary prayer. They call it voluntary because even though the teacher or a student leads the prayer, nobody has to actually participate, but the court says no. The government is in fact endorsing a particular religious understanding, and the government shouldn't be in the business of doing that. And so in a series of cases, beginning in the early 1960s, Supreme Court winds up ruling against kind of teacher-led or school-sponsored prayer and Bible reading. And then there are a series of cases involving the teaching of evolution, beginning in 1968, a case called Epperson versus Arkansas, where the state of Arkansas had prohibited or banned the teaching of evolution, largely based on the fact that the legislators believed that evolution was inconsistent with belief in God or their particular version of Christianity. Court said that was religiously motivated. Subsequent case, Edwards versus Aguilar, same kind of thing. And then we have the Ten Commandments cases. So beginning with a case called Stone versus Graham, the state of Kentucky said that the Ten Commandments had to be posted on bulletin boards. Court said that is a religious text, and the state of Kentucky can't do that. And then there were cases going up to early 2000s, McCreary versus the ACLU, and also a Kentucky case where the court ruled against the state of Kentucky, and then one involving my own state, and that case also involved the Ten Commandments, but it was concerning a monument that was kind of difficult to, single out, and so the court said that it really wouldn't be perceived as the state sponsoring or endorsing religion. But the key thing to remember here is that the court is in fact saying that there's something distinctly special about religious speech. So let's say if you go back to the cases involving school curriculum, if a teacher, let's say, stood up at the beginning of class and told you, rehearse the periodic table, that's not unconstitutional, but the teacher stands up and lists the Ten Commandments and saying you should memorize that, that's actually probably exceeds the right of that teacher to do that in a classroom setting. So there seems to be two different principles here. And one goes something like this, that whenever the government sets up a limited public forum, it cannot exclude public benefits based on viewpoint, even a religious viewpoint, since religious speech is a species of speech. The other cases, I think, say something like this: the government may not support or endorse a religious viewpoint, even if the viewpoint is integral to the lives of most citizens. So what's the difference between these two cases? Why is religious speech in the first set of cases not special, though it helps religion, while in the second set of cases it is special, though it doesn't help religion? Oh, could somebody hand me my water bottle? I forgot that I'm in Arizona. I'm sorry, did... Oh. All right, thank you. I grew up in Nevada. I should remember how it is in the dry climate. What? When was that? When did I grow up? I haven't grown up yet. No, when did I grow up? Well, I grew up in the you want to tell my age, right? So I'd have to reveal my true identity. So what's the difference? So one set of cases, it seems as though, that religion is not special when it helps it, and then it doesn't seem to be special when it doesn't. Now, it seems to me that there is a difference, and an important one, is that in the first set of cases, the government merely provides the venue in which contrary points of view may be advanced by private parties, whereas the second set of cases, the government is in fact the actor, and because the state may not take sides on religious issues, as the conventional reading of the Establishment Clause suggests, religion is in fact special. But what exactly is it that makes religion special? That is, how does it differ from, let's say, other kinds of activities or points of view? After all, the same teacher, as I mentioned a moment ago, who is free to instruct her students on chemistry or literature, cannot lead them in prayer, teach them creationism, or put the Ten Commandments on her bulletin board, even if approved by her state employer. So there must be something about religion that earns this exclusion. Now, it seems to me that what makes religion special for this reason is something that was addressed by James Madison in his Moral Remonstrance, which was a letter that he had written in response to that law that I mentioned earlier that Jefferson also opposed. It's that there is something about religion and it's the kind of duty that people think they have towards their faith and God that differs from other kinds of relationships. And here I'm going to quote from Madison. Because we hold it for a fundamental and undeniable truth that religion or the duty which we owe to our Creator and the manner of discharging it can be directed only by reason and conviction, not by force or violence, the religion then of every man must be left to the conviction and conscience of every man, and it is the right of every man to exercise it as these may dictate. The right is in its nature an inalienable right, unquote. So often accompanying this approach to religious liberty, or at least the anti-coercion aspect, or what would sometimes call the Establishment Clause aspect of this, is a kind of epistemic modesty on matters of religious conviction. What is epistemic modesty? Well, the word epistemic, for those who have not studied philosophy or are unacquainted with it, refers to knowledge. So when I use the term epistemic modesty, what I'm suggesting is that you can be rational in holding a belief that someone else may think is wrong, and they may be rational in thinking you're wrong. So you see this oftentimes in the way in which, well, let's say, we deal with political disagreement, right? So I have lots of friends that I think are wrong about political issues, but I don't think they're crazy. Right? I can see why they think the way they do, even though I think they're mistaken, and hopefully they can extend the same kind of, charity to me as well. So let's say, for example, I'm convinced that I have warrant to believe that X is a divine command that I ought to obey, you may not be convinced of that. So according to someone like Madison, the citizen who employs coercion on his neighbor to practice what the neighbor finds no warrant to accept risks divine judgment. So it's interesting the way Madison sort of frames this. He says, quote, here's a word that they used back then and we don't, whilst. Whilst we assert for ourselves a freedom to embrace, to profess, and to observe the religion which we believe to be of divine origin, we cannot an equal freedom to those whose minds have not yet yielded to the evidence which has convinced us. If this freedom be abused, it is an offense against God, not against man. To God, therefore, not to man, must an account of it be rendered." Unquote. So interesting enough, there's this aspect of the way in which Madison and some of the early founders thought about religious liberty, that on the one hand, it did involve reasons, but on the other hand, people had this sense of duty. So this is the way I try to explain it to my students in class. I tell them it's almost as if your religion chooses you and you don't choose it. I don't know if you've ever had this experience before where you know that you have this sort of conviction, this matter of conscience that you ought not to do something, but you really can't come up with like a knockdown, drag-out argument that would convince somebody else. I mean, think, for example, of the way we disagree on issues like war and peace, right? I have friends that are pacifists, and I am not a pacifist. I think they're wrong, and I think I understand their views, and I respect their views, but I'm just not convinced their arguments work, right? And so there's a sense in which, at some point, arguments are sort of not gonna do the trick, right? They can only take you so far. And I think that's what I think some of the American founders are trying to capture, this kind of deep belief that sometimes we have about things that we think we have good arguments, but they're just not good enough, though, to convince other people. And there may be beliefs that we hold that we just don't have arguments, but it's still reasonable to believe. So think of something like it's wrong to torture children for fun. I mean, if you were pressed to come up with an argument as to why that's wrong, right? I mean, you could, right? You could say, well, it's just, if you don't see that it's wrong, there's something wrong with you, right? And so sometimes on certain matters, that's the way in which we kind of have to end the conversation, right? It just, and I think there was an understanding, especially with American founders, that had a memory of what it meant to live in a part of the world where there was religious persecution, real serious religious persecution. All right, so what makes religion special for Establishment Clause purposes? That it concerns questions about one's duty to that which is ultimate, may illuminate certain contemporary questions. So this is the part of my talk where I'm going to offer something that I had actually never really thought about until last semester. And so I'm looking forward to hearing your comments about this and the comments of my fellow panelists. So take, for example, the case of Samantha Uluf, a young American Muslim woman who was denied employment by Abercrombie & Fitch because she could not remove her religious headscarf if hired. The company had a policy that all of its employees dress in a way that projects a certain look consistent with the image it wants the buying public to associate with its brand. According to Abercrombie, an employee wearing a traditional Muslim headscarf would not project that look. The U.S. Supreme Court, however, in an 8-1 decision, held that the company had violated Title VII of the 1964 Civil Rights Act as amended, which states that employers cannot, quote, fail or refuse to hire or to discharge an individual or otherwise to discriminate against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin, unquote. Because the Act defines religion to include both beliefs and practices, and because it requires the business to accommodate reasonably, it doesn't matter whether the government, the store's policy is neutral on its face. Right? So this is not a First Amendment case. This is a case involving a federal statute, but I think it does tell us something about how religious expression, in this case, the way in which this young Muslim woman wants to express herself to the rest of the community. So what stands out about it is that you really can't come up with a secular or non-religious parallel to Ms. Uluf's plight. She believes that she's commanded by divine sanction to wear the headscarf. Now, to be sure, other employees may want to wear the exact same headscarf for a variety of other reasons, including, let's say, impressing one's spouse, hiding a birthmark, personal modesty, wardrobe aesthetics, or expressing solidarity with one's persecuted Muslim friends. But none of these cases includes anything like a divine command. For Miss Aloof, not wearing the headscarf constitutes disobedience to a sovereign she did not choose. It does not constitute the exercise of a personal choice in response to contingent, self-regarding, and communal circumstances, as it does in the other cases. Now let's consider a fictional case. The fictional case of Joel Goldberg, owner of Goldberg's Photography, whose employees consist of Goldberg and his family members, all of whom are Orthodox Jews. Located in Denver, Colorado, the business has never run afoul of any of the region's anti-discrimination laws. Imagine that Goldberg is approached by a local Christian minister, we'll call him Mr. Convert, or the Reverend Convert, I suppose, to take photographs at the church's upcoming biennial baptismal ceremony. The minister informs Goldberg that the church plans to post the photographs on its website as a way to publicly welcome the baptized into the community. Goldberg then asks him, by the way, what is the name of your church? And Mr. Convert says, Rocky Mountain Jews for Jesus. He goes on to tell Goldberg that it is a Christian congregation consisting exclusively of converts from Judaism, including 4 adults whose baptism Goldberg is being asked to photograph, and all 4 of those adults were former members of Goldberg's synagogue. Goldberg then tells Mr. Convert, I'm sorry, I will not cooperate with the celebration of a liturgical event that I believe is apostasy. He goes on to explain to Mr. Convert that he would have no problem photographing the same 4 individuals near or in any body of water, including being playfully dunked by the minister in, a pool. But baptisms, he argues, because they are liturgical, are different, and most especially so when they involve the public renunciation by others of one's own faith. Not pleased with the news, Mr. Convert files a complaint with the Colorado Human Rights Commission, arguing that Goldberg's refusal constitutes unlawful discrimination based on religion. At trial, Goldberg insists that it is not Mr. Convert's religion that is the issue, but rather the activity for which Mr. Convert is asking Goldberg to employ his artistic gifts to assist in celebrating. This activity, argues Goldberg, has deep liturgical significance for both himself and Mr. Convert. For Mr. Convert, it is done in obedience to his faith. For Goldberg, not doing it is in obedience to his faith. And yet the Colorado Human Rights Commission rules against Goldberg, stating the following, quote, the Supreme Court has recognized that in some cases conduct cannot be divorced from status. This is so when the conduct is so closely correlated with the status that it is engaged in exclusively or predominantly by persons who have that particular status. We conclude that the act of baptism constitutes such conduct because it is engaged in exclusively or predominantly by Christians. Therefore, Goldberg's distinction between not serving Christians and not cooperating with the celebration of baptism is one without a difference. But for his religion, Mr. Convert would not have sought to baptize his congregants. But for his intent to do so, Goldberg would not have denied Mr. Convert his services, unquote. By ignoring the liturgical significance of baptism to both those who believe in it and those who don't, by treating it as just another activity correlated with a citizen's protected status under the law, our fictional commission is not taking rights seriously. That's R-I-T-E-S. It is effectively redescribing a liturgical practice in terms alien to the citizens, both believers and non-believers, who do indeed take the practice seriously. One could, of course, just bite the bullet and argue that given some principle of equality, Goldberg just simply should be punished for this, even though the only way for him to avoid punishment, in the words of John Locke, is to, quote, join the worship and ceremonies of another church, unquote. But this seems to be the Platonic ideal of a violation of religious liberty that writers like Locke, John Milton, Roger Williams, Madison, and Thomas Jefferson had in mind. I should note at this point that the imagined holding of the Colorado Human Rights Commission is taken nearly word for word with just minor adjustments to fit the actual nonfiction case of the Colorado Court of Appeals ruling in Masterpiece Cake Shop, ultimately decided in favor of the vendor by the U.S. Supreme Court. So as in the fictional baptism case, the Colorado court rejected the defendant's argument that his refusal of service was not based on the status of the customers, but rather on the nature of the ceremony that he was asked to employ his talents to celebrate. It seems to me that the ruling of that Colorado court does indeed make sense, but only if one redescribes weddings in a way that eliminates their religious dimension that is integral to the observant citizen's worldview. For someone like Jack Phillips, the owner of Masterpiece Cake Shop, weddings, even though they are conducted under the auspices of institutions, either governmental or religious, that are outside of his own faith tradition, do indeed have liturgical significance. For religious believers like Phillips, weddings are more like baptisms, bar mitzvahs, and burials than they are like birthday parties, baby showers, or barbecues. So it seems to me that the same reason why religious speech is special in the school prayer and creationist cases, as well as the Ten Commandments cases, is the same reason why it is special in the cases of Miss Olaf and Mr. Phillips. It concerns a citizen's obedience to a transcendent authority that is not under his or her control. Thank you.
Hello. What a pleasure to not have the mask on. I already taught 2 classes this morning with the mask on, and I've been teaching all semester, but this is a thrill. Can you all hear me? Yes. Okay, so hi. So I'm here today to discuss the way that some recent decisions by the Supreme Court I think have redefined religious liberty and I think threatens our liberal democracy. I want to say at the outset that there have been a couple of references to the other side. I don't think I'm on the other side. I think that I think separation of church and state protects believers and non-believers alike, and I think it's the side of the Constitution, so I don't see myself as being on the other side. So I want to talk about some basics. Some of the panelists who came before me sort of helped out a little bit, so I may be being repetitive, but just to talk about liberalism a little bit, because I'm talking about how these cases threaten liberal democracy. So the worldview of liberalism springs from the Enlightenment, otherwise known as the Age of Reason. Some of you might have heard of the Enlightenment, which constituted a rejection of traditional social, religious, and political ideas with an emphasis on rationalism. It sought to apply reason to all sorts of human problems, including the problem of governance. Okay? Liberalism is a political ideology based on democracy, the rule of law, individual rights, and equality. In the United States, people live in a liberal democracy without even knowing that they do, and are committed to these ideals, even if they couldn't necessarily name them all as being liberalism. For most of our country's history, debates between the left and the right took place within the parameters of this worldview. Furthermore, since World War II, the United States has been the leader in promoting what is known as the liberal world order, which consists of promoting liberal ideas and values, including open and free trade, liberal democratic governance, universal human rights, collective security, international institutions, and the rule of law. And this liberal world order fostered unprecedented cooperation amongst states, aided in the development of democracy in formerly communist and fascist societies. And as long as I have been alive, politicians on both sides, and I'm not going to tell how old I am either, politicians on both sides of the aisle have supported a version of the liberal world order until quite recently. Gradually, over a number of years, for a variety of complex and maybe not so complex reasons, there's been a rise of authoritarianism, both in the United States and abroad. Politicians and regimes have cropped up to challenge the basic ideas of liberal democracy, free elections, the rule of law, equality before the law, and the rights of the individual. As I speak here today, the democratic nation of Ukraine has been invaded by an authoritarian regime in a way that defies the liberal world order that the United States spent the second half of the 20th century fostering. It's my position that democracies exist to protect the liberty of all of their citizens, and that the religious freedom enshrined in the U.S. Constitution is one of the crowning achievements of our nation. The separation between church and state requires governments not only to avoid religious establishment, but also to maintain religious neutrality. This has enabled the United States to flourish as a pluralistic country with a vibrant religious life. The promise of religious freedom has beckoned both believers and non-believers to our shores way before we called ourselves a country. And a multitude of religions and cultures exist side by side in this country. Not perfectly, but certainly less violently than in many other places in the world, probably most. Government decisions are based upon neutral principles of the common good, and there exists a marketplace of ideas in which the religious and non-religious alike are free to advocate for the principles which they believe. What I want to do is talk now about, we've heard a lot about the Establishment Clause and the Free Exercise Clause, so I just want to get into them slightly more detail, and forgive me if you already know all this stuff. Okay, but as most of you probably know here, even though some people say the United States is a Christian nation, it is not a Christian nation. In fact, the U.S. Constitution in its original form mentions religion only once, in Article 6, stating that, quote, "No religious test shall ever be required as a qualification to any office or public trust under the United States." So, meaning that one does not have to belong to any particular religion in order to hold public office, and that's it. Then, of course, we have the First Amendment, and we've talked about the First Amendment, and the First Amendment further spells out our religious liberty in 2 clauses. This is where I probably should have had a PowerPoint, since I'm doing a lot of reading, but what can you do? The first, the Establishment Clause provides, Congress shall make no law respecting an establishment of religion. One of the things about the founders is they did not believe in a lot of words. If you look at the entire U.S. Constitution, it's like, in a textbook, it's like 4 pages. If you look at the Arizona Constitution, it's like 30 pages or something. They use words sparingly, and most people think they did that on purpose to sort of allow the definitions of these words to go forward and sort of to not hem them in such a way. The framers understood, I think we can all agree on this one, that no establishment meant no national church. No church that is the official religion of the United States may exist. The founders also believed that there should not be government involvement in religion. And I think, in fact, Professor Lupu is going to talk about why government involvement in religion is bad for both government and religion. Long-standing precedents about the Establishment Clause indicate that the clause not only forbids the government from establishing an official religion, but also prohibits government actions that unduly favor one religion over another, or it also prohibits the government from preferring religion over non-religion or non-religion over religion. The Establishment Clause recognizes that there is no way that any government could possibly aid all religions in a fair way. Historical precedent demonstrates that government will inevitably pick a favored religion, which will be the majority and most politically powerful religion. And so the Establishment Clause protects religion by ensuring that government should have no say in the affairs of religious institutions. So that's the Establishment Clause. The second of the religion clauses provides Congress shall make no law prohibiting the free exercise of religion. Again, a model of clarity. Okay. It's a good thing that the Constitution is written this way because it gives lawyers like me and lawyers like on the panel a job while we all fight over what these 5 or 6 words mean. Again, long-standing precedents of the Supreme Court indicate that the Free Exercise Clause protects the right of people to worship freely according to the dictates of their conscience. While freedom to believe has always been protected, conduct based upon those beliefs can be limited if it conflicts with other societal values expressed in the law. In Employment Division versus Smith, Justice Scalia, the late Justice Scalia, a proud Catholic with 9 children, one of whom is a Catholic priest, said that the court's decisions had consistently held that the right of free exercise does not relieve an individual of the obligation to comply with a valid and neutral law of general applicability on the ground that the law prescribes conduct that his religion prescribes or prescribes. That seemed like it made more sense when I was typing it, but maybe in English. In other words, if a regulation is not aimed at religion, but happens to catch religion in its crosshairs, it is not violating your free exercise of religion. So, for example, we have laws that say you can't steal, okay? A Jew cannot say, well, stealing is part of my religion, so I get to do it, and because otherwise I don't have free exercise of religion. We would say no. If the law said Jews can't steal, then it would be a free exercise problem. But if the law just says nobody can steal and it happens to catch your religious practice, well, at least according to Justice Scalia and Smith, that's not the way that it works. Now, Justice Scalia said, such an approach, quote, must be preferred to a system in which each conscience is a law unto itself, or in which judges weigh the social importance of all laws against the centrality of religious beliefs. Now, it's complicated, but the Smith test doesn't always apply. Not everybody loves the Smith test. A lot of people would like to see the Smith test go away. The Supreme Court and some members of the current Supreme Court have indicated that they might like to see the Smith test go away. But even in cases where Smith doesn't apply, government policy that substantially impinges on someone's free exercise rights must satisfy strict scrutiny. Therefore, that is justified by a compelling state interest. And I hope you'll indulge me. I have a rather long quote by Justice Sandra Day O'Connor, which she is talking about the goal of the religion clauses. And this is Justice O'Connor in McCreary County versus ACLU, which I've forgotten the year. It's maybe 2005. The goal of the religion clauses is clear: to carry out the founders' plan of preserving religious liberty to the fullest extent possible in a pluralistic society. By enforcing the clauses, we have kept religion a matter for the individual conscience, not for the prosecutor or bureaucrat. At a time when we see around the world the violent consequences of the assumption of religious authority by the government, Americans may count themselves fortunate. Our regard for constitutional boundaries has protected us from similar travails, while allowing private religious exercise to flourish. Those who would renegotiate the boundaries between church and state must therefore answer a difficult question: why would we trade a system that has served us so well for one that has served others so poorly? So, the two religion clauses together exist in a delicate equilibrium. If, in an attempt to adhere to the Establishment Clause, the government objects to any religion in public life, it threatens the religious liberty protected by the Free Exercise Clause. If the government chooses to protect religious liberty over all other democratic values, such as equality, It threatens to establish religion in law in violation of the Establishment Clause. It is my position that current Supreme Court decisions, largely in conjunction with more conservative appointments to the Supreme Court, have upset that balance, virtually eviscerating the Establishment Clause. The result is that the government appears to be endorsing the worldview of religion in general and Christianity in particular, thereby treading exactly where Justice O'Connor said we do not want to go. So, quickly, some of these cases. Burwell versus Hobby Lobby, in which the Supreme Court ruled that requiring an employer to provide health insurance, which included some forms of birth control objectionable to the employer, was a substantial obstacle to the business's free exercise beliefs. And if the government believed women should have this access to contraception under the Affordable Care Act, the taxpayers could pay for it. Trinity Lutheran versus Comer, which held that the First Amendment's free exercise clause was violated by Missouri's refusal under a provision of their constitution which prohibited aid to religious schools to award a grant to a church school to resurface its playground. It was discrimination against religious schools, said the court, against religion to exclude religious schools from the program. Espinoza versus Montana Department of Revenue. Sorry, I did not give the years for the others. This is 2020. I believe Trinity Lutheran is 2017. Espinoza, in which the Supreme Court found that if a state allowed tax credits for those who donated to non-sectarian schools, they cannot disqualify some private schools solely because they are religious. The court reframed Montana's attempt to avoid violating the Establishment Clause to be a discrimination against religious schools. Result, taxpayers funding overtly religious education, including that which might clash with their own religious conscience. Tandon versus Newsom, 2021, in which the Supreme Court held that even though California's COVID rules limited both secular and religious in-home gatherings to members of 3 households or less, religious in-home gatherings must be exempted from the limitation because various businesses were not subject to the same limitation. 2 more, folks. Fulton versus City of Philadelphia. In this case, Philadelphia had a requirement that private agencies that receive city funding do not discriminate against any community they serve, including members of the LGBTQ community. Catholic Social Services was one of the adoption agencies which received such city funds in connection with adoption placements. A unanimous Supreme Court decided that since the city allowed other exceptions to its policy, it mustn't allow an exception for these religious beliefs of Catholic Social Services. And finally, Carson versus Mackin argued this term in which the Supreme Court seems poised to rule that Maine must give public education funds to all private schools, including those that, for example, teach a thoroughly Christian and biblical worldview. Ironically, some of the schools in question have indicated that they will not accept these public tuition payments, as doing so would require them to comply with the Maine Human Rights Act, which would require them not to discriminate against gay instructors, for example. So the schools themselves certainly seem to understand the implications of entangling government and religion. Under these recent interpretations, then, any denial of government benefits to a church, even if clearly done with an attempt to avoid the Establishment Clause, is discrimination. Religious people are exempt from obligations that bind other citizens. Instead, we live in a world in which each conscience is a law unto itself, in direct contravention of Scalia's admonition. The Establishment Clause has been rendered meaningless, and a religious worldview can animate our policymaking. So what, you ask? I suppose that many people here are not bothered by these decisions and that they seem fair to you. After all, how can we be free to practice our religion if we have to comply with laws that conflict with it? And I suspect that a lot of people are comfortable with these decisions because most people feel comfortable with their religions represented here. I wonder, though, if people would be as comfortable with the idea of allowing an employer who is a Jehovah's Witness to refuse to provide health insurance, which covers blood transfusions, or state funds going to one of the 250-plus Muslim schools in this country, or the Satanic Temple claiming an exemption from abortion prohibitions on the grounds that abortions are one of their religious rights. I submit to you that if we destroy the liberal cornerstone of separation of church and state, if we allow a religious worldview to permeate our institutions and to replace secular democracy, no religious minority, including the non-believer, will be safe to practice according to the dictates of their conscience. And one day, you might find yourself in that minority. Now, as I'm a lawyer, I've gone over time, so I'm going to cut my remarks short, but I just want to briefly point out that you might think this is all just kind of like a lot of hyperbole, and I'm just sort of getting all worked up about nothing. But today, our very democratic freedoms are under assault from Christian nationalists. Christian nationalists believe, contrary to our Constitution and our history, that the country is and should be a Christian nation governed by Christian principles. In other words, Sharia law. I hasten to add, I am not talking about all Christians. I am talking about a group of Christians who believe that religious identity and national identity overlap completely. This Christian nationalism has a racial component to it. The Christian nation that they envision is a white Christian nation. Under this view, those who do not adhere to their version of Christianity are not really Americans. If they are not really Americans, then they're not entitled to the benefits of citizenship, including civil liberties and civil rights. And I'm going to leave it to Peter to talk a little bit more about Christian nationalism, but just one more thing. In its most extreme form, Christian nationalism legitimizes the type of violence we saw on January 6, 2021. An insurrection that killed one police officer and likely animated the subsequent suicides of 4 more. Christian nationalists played a large role in the first attack on the U.S. Capitol since the War of 1812, an attack aimed at overturning the results of a legitimate election. And so when I warn here about the dangers of stepping away from the separation of church and state, I'm warning about the kind of dangers inherent in the threat posed by Christian nationalists. Thank you very much. It was a pleasure talking to you, and now I'll just put the mask back on.
So to get this out of the way, 4 days ago, I became 74. First, I would like to thank all my panelist colleagues for coming and giving all of us their knowledge and wisdom. I also would like to thank those who organized this event, Derek Ayala and Richard Claus. But come to think of it, when I look at the panelists and their titles, I think they wanted to humiliate me. Because notice, every one of the first 3 has this thing called JD in their title.
That humiliates us.
And I don't have any of that. JD, I think, is a law degree, isn't it? So they put me, a humble student of philosophy, with 3 lawyers talking about the First Amendment, right? Well, let me tell you what I'm going to do. I want to first talk to you a little bit about corruption, the nature of corruption. Then I'm going to talk to you about my understanding of the two clauses of the First Amendment, the Establishment Clause and the Free Exercise Clause. And then I'm going to talk to you a little bit about different ways in which the Establishment Clause is eroding, or different attempts to erode or nullify it. And then I'm going to circle back to corruption. So, let me begin. The title of my talk, as you can see, is Whenever Religion and Politics Merge, Corruption Consumes Both. So wherever I'm going to say, I'm concerned about both the political system and religion communities. I'm going to try to show you some historical examples of what happens when those two intermix. Second, I will give you some examples of some corruption cases or corruptive trends today. And then I'm going to argue that attempts to trump, that's not the one, the Establishment Clause will lead to corruption. So that's what I'm going to do. First, let me introduce you to some instruments of power. And remember, power is about control, and absolute power is about absolute control. So here are some instruments of power. Sheer force is an instrument of power. Political power is also an instrument of power through laws, political institutions, enforcement agencies, like police and so forth, courts. Wealth is also an instrument of power. Numbers, masses of people, can be instruments of power. Social status can be instrument of power. And of course, as we know, information, media, social media, etc., very powerful instrument of power. So these are some examples of instruments of power, all of which are about control. The degree of control varies, of course, and the purpose of the control varies. Now, let me introduce you to two principles. First, institutional corruption. This principle is general, applies to all institutions, including education institutions, which is where we are at now. Institutions, organizations, movements which change their original mission to pursue instruments of power are corrupted. So, for example, to mention an example we discussed in our club last time, the mission of a doctor is to heal. And I'm an essentialist about that. That's the essence of being a doctor. But if you have a doctor that goes into being the medical profession in order to make money or to have a comfortable life, and that's their main mission, where healing becomes secondary, they are corrupted. So that's an example that has nothing to do with what we are doing, and this applies to institutions, organizations, and any movement. If they change their original mission to pursue an instrument of power, they are corrupted. Now, occasionally, institutions, of course, have a mission, and they need to raise money. Education institutions, they need money to survive. But if they turn money to be their main mission, they are corrupted. And so I believe that there is no such thing as for-profit education. Let me give you some historical examples of how religion, when they change their mission, get corrupted. I'm going to give examples from Christianity, but this is true for all religions. So I want to emphasize that. It's true of Islam, Judaism, Hinduism, whatever you want. And you can find examples for each of them throughout history. But since we are talking right now about the Establishment Clause and things that are going on in our country, I want to talk about the majority religion here, which is Christianity. So, I will give you a little history, very quick, and I'm sorry that I can't go into depth because I will go over my time. Number one, before Constantine turned the Roman Empire into the official religion of the Roman Empire to be Christianity, Christians were persecuted terribly by the Romans. As soon as Constantine declared the official religion of Rome to be Christianity, and there were several councils to develop the doctrine, the canons, and then which books are official books. What happened? Christianity used the power of Rome to persecute others, including some Christians that were considered heretics. That's a historical example. Second, the Inquisition. That's another example where, during the Middle Ages, there were certain sects, Christian sects, that grew in particularly beginning in France, and they began to have the numbers, so they became a threat to the official Catholic Vatican. So the Vatican made arrangements to develop this Inquisition, which then spread to Spain and other places, and it really persecuted anyone who they thought was heretics, and then it spread to other religions as well. Why did that happen? Because the state had a symbiotic relationship with the church. 30-year war, 1618 to 1648. 8 million people perished in the 30-year war. And what was that about? Well, the Protestant split between the Protestant and the Catholic happened. Various different monarchs chose one or the other, and they fought against each other. Granted, there were other political causes of the wars too. But the symbiotic relationship between the state and the church was a major part of the 30-year war. So these are examples where when you have a symbiotic relationship between the religion, any religion, and state power, terrible things happen. And the terrible things happen are often against the fundamental tenet of religion as well. There are other examples of this happening. For example, you have theocracies in Iran and Saudi Arabia, where the non-majority religions are persecuted, including many other people are persecuted. That is because the state and religion are either totally identical, or like in Iran, or there is a very close symbiotic relationships, and therefore state power is used for religious purposes. symbiotic relationship like this evolved and evolving now in countries such as India, the biggest democracy, and it's happening. That Saudi Arabia and Iran are theocracies, that is, ruled by religion, roughly. And even in Israel, this is happening. And of course, Spain under Franco, where the Catholic Church operated as an auxiliary to the government. So these are examples of what happened in history when religion and state power get into a symbiotic relationship. Now, I want to turn into some other kind of corruptions, just to give examples, that I perceive that threatens religion, in particular Christianity. Not that I'm Christian, but I'm concerned about the corruption of religion. Something that happens within Christianity with very little opposition. I have in mind prosperity gospel. Let me just give you a couple of examples. Joel Osteen, who is a multimillionaire televangelist in Texas, is worth $80 to $100 million. He has 2 mansions, at least. I don't know. That was at least 10 years ago. One of them was worth about 10 years ago, 10 point some million dollars. The other one over 2. He is an evangelical. He's televangelical. Promotes Christianity. To make money? To pursue an instrument of power? Is that walking in the footsteps of Jesus? I can't think of anything opposite to that important figure in history than using religion for that purpose. And then we have, of course, Paula White, whose wealth is estimated at $5 million. Oh, by the way, she was Trump's spiritual advisor. I don't know how many of you saw the pictures of Trump sitting and all of these advisors and sort of parents. Doesn't look like it helped much. So, principle number 2. Entities, individuals, and institutions whose sole mission is the pursuit of instrument of power inevitably aims for monopoly of that power. Why is that? It's very simple. If your primary pursuit is instrument of power, then you're pursuing control, because that's what power is. Other individuals and entities that pursue also control or power become now your rivals, competitors, and even enemies, because they too pursue the same instrument of power. And since usually instruments of power are limited, your purpose is to grow yours and reduce theirs. So conclusion is the pursuit of instrument of state power by religious communities inevitably corrupts them and the political environment in which they operate. This is true historically, and it becomes true now. And what I came here to do is to warn against that, because what's happening today, for some time now, is there are various different ways in which certain religious movements in this country aim to pursue instruments of power in order to advance certain religious goals. I think that corrupts them, but it also corrupts the political system in which they operate. So let me say a few words first about the Establishment Clause and the Free Exercise Clause to understand exactly how they relate to each other. And again, this is very interesting how this is phrased. Congress shall make no laws respecting an establishment of religion. That's the Establishment Clause. First, no laws is absolute and general. But this Establishment Clause does not, as others said, simply prohibit making a law declaring an official religion. Because if that's what they wanted to say, then it was easy. They could have simply said, Congress shall make no laws establishing a religion. That's all you need. So I kept wondering two things. What respecting means and what an establishment of religion means. It's not simply Congress shall make no laws establishing a religion. It says respecting an establishment of religion. So I was pondering that, and I concluded that, well, Congress was, as the lawyers know better than I do, it was generalized to mean any government authority, federal, state, local. But I was focusing on the respecting. What does respecting mean? What could they mean? Well, respecting means acknowledging, recognizing, affirming, accepting, and endorsing. I suggest all of these are in the scope of Congress shall make no laws respecting, endorsing, accepting, affirming, recognizing, or acknowledging something. Well, what is that something? It is an establishment of religion. Well, what does that mean? I suggest that an establishment of religion means any place or form in which religion is established, exercised, or manifested, such as religious institutions, religious practices, religious symbols, religious rituals, religious speech. So if we put this whole thing together, and hi Chuck, how you doing? We get the following. Congress, federal, that means any state authority, federal, state, local, shall make no laws absolutely general, respecting, that is, acknowledging, recognizing, affirming, accepting, endorsing, and the establishment of religion in the following areas: religious institutions, religious practice, religious symbol, religious rituals, and religious speech. Now let's turn to the Free Exercise Clause. Very, very short, as therein pointed, prohibiting the free exercise thereof. Notice thereof refers back to what? Prohibiting the free exercise thereof refers back to those things that come under an establishment of religion. So that means you cannot have any laws, the no laws ranges over this as well as the other clauses. And it means that there cannot be any laws prohibiting religious institutions, religious practice, religious symbol, religious rituals, and religious speech. So what we have here, as all the other panelists said, there is this two spheres that the First Amendment, this part of the First Amendment, attempts to delineate and separate between them. And now the question is how courts and as a society we decide to reconcile them in many, many cases when they seem to conflict. But at the same time, it's extremely important to realize that the intent was to have two spheres, separate spheres. The sphere of the political arena and the sphere of the religious arena. And the political arena cannot recognize and so forth, acknowledge, affirm, endorse any specific religion, anything from the religious sphere, but at the same time cannot prohibit those activities I enumerated. So now, let me go to my last part and try to get through it very quickly. That is what usually is called the wall of separation of church and state, even though church, of course, is not mentioned and state is not mentioned. It's about any religion. Doesn't matter what it is. What is the constitutional crisis that we are living under for some time now? There were powerful religious forces which attempted to challenge the Establishment Clause. There are two strategies that you can take to do that. One is what I call the revolutionary strategy. Amend the Constitution, eliminate the Establishment Clause, and therefore we can declare laws which establish a religion, official religion in this country. But who would promote this? Then anybody that would promote this at all? The answer, absolutely. Within the Catholic tradition, there are the so-called Catholic integralists who, what?
No, I said I know some of those guys.
You do?
Unfortunately,
Excellent,
yeah.
you can tell us about them.
None of them are on this panel.
What? None of them are what?
On this panel.
No, I didn't say. Yeah, no, I didn't. Oh, Pastor Kalila. No, absolutely not. No. I just used the Yiddish word to say absolutely no, God forbid. So the Catholic integralists basically call to eliminate the Establishment Clause because it is an obstacle to declaring and making laws which are purely religiously oriented and binding on everybody. So here are some quotes. And by the way, let me point out, there are very powerful people that are connected to Catholic integralists in our government. Maybe in the Supreme Court too. Here's sources. U.S. Catholic site has an article called What is Catholic Integralism by Stephen Millis. Central doctrine. The aim of the Catholic integralist is the integration of religious authority and political power. The only way you can do that is if you remove the Establishment Clause. Commonwealth, the new integralist. Another essay, integralists do not aim to pursue a Catholic agenda within a pluralistic societies that defend religious freedom and other liberal rights, but to dictate the very terms in which the public square is understood. Their ultimate hope is to create integral Catholic regimes that subordinate temporal government to the spiritual authority of the church. So these are cases of not learning from history and trying to repeat it. It's worst part. This is what this is about. Why am I wearing this? How stupid.
You just figured it out.
I just realized that I didn't take a break. Ay. Now, but this is not only within the Catholic tradition. In the broadly Protestant tradition, the same analogous movement happens. They're called Dominion theology. Dominion theology, here's a little quote as what that is, in a Political Research Associates, there's an article called Dominionism Rising, a theocratic movement hiding in plain sight. Dominionism is the theocratic idea that regardless of theological view, means, or timetable, Christians are called by God to exercise dominion over every aspect of society by taking control of political and cultural institutions. There's another quote, long one, I don't want to read it. What's going on in Texas? Many of the politicians in Texas are Dominion or influenced by Dominion theology. By the way, this is a quote from that article. So who started Dominion theology? Well, it was in 1970s. The father of hard Dominionism, the late Presbyterian theologian R.J. Rushdoony, called for his followers to, quote, take back government and put it in the hands of Christians. These are the revolutionary strategies. Now I get to the piecemeal salami strategy. This strategy is basically to chip away at the Establishment Clause by relying on the Free Exercise Clause. This is the majority of those Christians, but not just Christians, who feel that the secular values have been too dominant in our political system, and it is time to balance things out by relying on the Free Exercise Clause. And this is a question that you all have to think about. This is a question that Richard and I keep discussing a lot. Christians, let's say, talk about Christians, have a value system. Don't they have the right to try to inform, but also incorporate into the fabric of society their values, like, for example, through certain laws? This is a very difficult question that we have to answer as a society. And then, of course, how you do it that is consistent with the spirit of the Establishment Clause and the Free Exercise Clause. Because my belief is, and I think it's fairly obvious, that the First Amendment was inspired by the experience of the framers of the European experience and the persecution and wars created primarily because of the merge between religion and state power. So what is the piecemeal strategy? I run through it very quickly. The idea is that everybody has a worldview, and that worldview includes values. Religious people have a worldview, which you heard here today, very well expressed. They have values that are inspired by their religious beliefs, essentially, eventually tracing back to the authority of God. And therefore, that means that anywhere a religious person goes, their values go with them, their worldview goes with them. You cannot separate an activity of a religious person, a project, from their worldview. And by the way, that applies to secular people as well. Therefore, when religious people, let's say in this case Christians, go into the public domain, they have a right to express their worldview. and through their activities, be informed by their worldview, including in the political arena. So what I'm suggesting is that the sort of theoretical, intellectual justification for involvement in the political arena and aiming to acquire political power is that religious people have no choice about it. They must manifest their worldview in their political activities. That is the strategy. And by the way, this strategy is expressed very well in this book written by, well, no other than Dr. Francis Beckwith. The introduction to this book, it's by the way a series of books, there are many of them, is written by Dr. Beckwith and a very philosopher from, where is Moreland from? Biola. J.P. Moreland. And it is basically lays out the foundation for this kind of a view. Now, let me just say something. I do not believe that Dr. Beckwith or Moreland want to take over the country, but let me say something. They may be opening the floodgates, but they won't. They won't control the floods. Others will control the floods. And those who will control the floods, unlike the people on this forum, won't control. And so what I am worried about is that the religious community in the country faces a fundamental problem, which is how to convert their religious values, how to express them in a society that is assumed to be secular. How to do it? By gaining more and more power, which is right now, in my opinion, is the way we are heading. Or by the traditional way, which is through example, persuasion, this kind of debates and talks, by gaining one conscience at a time. That was the traditional view. But people want to hurry. And these influences of the Dominionist and the Catholic integralists infiltrated throughout the last 5 decades the broader Christian community, and together with some other things, I believe it's corrupting them. And that is very dangerous. Now, other forces are also at play at the same time to undermine our democracy. So I just wanted to tell you something. This is the Constitution of the United States. It is the foundation, the ground on which you stand, the air you breathe. Everything is structured around this. If this is gone, your life will be completely different. It will never be the same. You are the only one that can protect us. But you have to study, and you have to understand both sides of every debate. See what is the motivation of the other side, where they come from, what are their concerns. But my concern here is that by pursuing state power, political power, religious communities are corrupt. I haven't seen much opposition to the corruption that is pursued by prosperity gospel. I didn't hear any opposition to that of any significant kind. And that is what corrupts Christianity from within. So I'm worried about that. Thank you.
Well, I enjoyed that, and I hope everybody else did. And so now for the next 20 minutes or so, we're going to open up the panel to each other so they can sort of get a little bit more specific in their questions and answers with regarding the various positions. So I'm going to let you guys, I guess, just do what you do best, whoever wants to go.
Let me, I'll start with an agreement statement. I do not think the United States was founded as a Christian nation, so I think we agree on that. I do think, however, it had what's known as a Christian founding. I would refer to Mark David Hall's good work, as well as Daniel Dreisbach's good scholarship with respect to that. I think that's going to be very important. With respect to Peter's remarks, and I have remarks for both folks who went before me or after me, I think there's an ambiguity in this notion that we talk about religion and politics merging. The ambiguity is, what is religion? And what's the scope of that objection? For example, if I say I oppose capital punishment, there's people in this room would say that's great. If I say I oppose capital punishment because that's what Jesus would do, that would be, I guess, mixing politics and religion. So it seems to me there's no limiting principle with respect to that. Moreover, why is it a one-way ratchet? Why is it that the mixing always corrupts, if that's your position? Why can't they be mutually beneficial? For example, the Christian tradition tells us to honor the emperor, to pay taxes, I wish it didn't say that, to pray for those in authority, to honor those, to be kind to all, to treat people well. That kind of merging, to me, seems to be quite beneficent to both sides of it. So I think there needs to be some greater unearthing with respect to that, as well as going into public square. Martin Luther King Jr. had religious motivation, religious tactics, and that was correct in promoting civil rights with respect to that. I think we also it has a problem because it presupposes that Christianity, for example, is not inherently religious. And yet there's many thinkers who would say, no, there's an inherent political nature, but it's not an ultimate nature. It's a penultimate nature. So, political philosopher Douglas Farrow, philosopher James K.A. Smith, and any number of other people, Oliver O'Donovan, theologian, would all take that perspective. So I don't think we have to get there. And finally, I would just say the notion of respecting, I think respectively you left off one respect, because the historical understanding was that respecting meant to either promote, endorse, set forth, or to diminish. And the reason it was in the First Amendment was because most of the colonies had established churches. So you couldn't increase it, nor could you decrease it. And this is testified to by the fact that there were clergies and the funding of Bibles out of the federal treasury. We have chaplains to this day, and that's not unconstitutional. It's not an unwarranted establishment. And then finally, I'll be brief because I have so many things to say, but the notion of Article 6. Take a step back. By my count, 19 out of the last 20 cases where the court has dealt with religious issues have affirmed religious liberty 19 out of 20 times. They didn't talk about establishment. What they said was there has to be equal treatment among religious groups and the others. That's Espinoza, the equal to that. You can't coerce unbelief against consciences and so on and so forth. That's not establishing religion. Those were all either free speech or religious liberty cases. Most of my friends argued them or participated in them, so I don't see that. And then you go to Article 6, which talks about religious tests. But read the rest of the article. It talks about oath-taking. Oaths are an inherently religious act. The Constitution requires an inherently religious act. It says you will swear or affirm. Affirm, is that a secularist notion? No, that was a religious accommodation to the Quakers who would not swear. So this idea that there's this metaphor of a wall, really does not exist historically with respect to that. So anyway, there's some questions there, and I appreciate some dialogue.
All right. Is it okay if
Absolutely.
Okay. Yeah, there's,
Okay, I'm going to take a Taoist approach and be real hands-off on this.
All right. So, I mean, there's much of what all three of you said that I agree with. I do have just sort of an observation about the way in which I think liberalism has sort of been cashed out. What I mean, by the way, when I use the term liberalism, I don't mean sort of what we typically associate with the Democratic Party. I'm talking about sort of this sort of grand understanding. I think you articulated it well, Terry, and that is this kind of understanding that there are these fundamental rights that we have and that the role of government is to protect them. But I think the way in which sort of it gets it gets cashed out in our public square. Let me give you a sort of illustration from some of the cases that Terry brought up concerning the recent Espinoza case and Trinity Lutheran, and the fact that Terry made the point of that these are that the sort of standard when it comes to evaluating religion cases is employment division versus Smith, and it is right now. But the way I read those cases, they're actually consistent with employment division versus Smith because they're actually concerning laws that single out religion for a special burden. So it seems to me that would actually be consistent, at least one reading of it, right? So something that Peter brought up, you talk about the integralist, and I actually have an article that's coming out in about 2 weeks in BYU Law Review. It's called Separated at Baptism, How Integralists and Progressives Both Deny Natural Justice. And so, and this is the real quick argument. So there was this 19th century case that I'm sure you're familiar with concerning a kid named Edgardo Mortera, who was his nanny. He was a Jewish infant who had an Italian Catholic nanny that baptized him without the parents' consent. Well, Rome finds out about it several years later. Pius IX, the Pope, abducts him and actually brings him up in the Vatican. Steven Spielberg has a movie coming out on this. Yeah, literally soon. And so the thinking was, this was the thinking of Pius IX. As a Catholic, I disagree with Pius IX. In fact, the purpose of the article is to critique that view, is that there's this long tradition within Catholicism that goes far, but it's best articulated by Thomas Aquinas in the Summa Theologica, and that is there's such a thing called natural justice, and that parents have the fundamental right to educate and religiously form their children. And so Pius IX, I argue, and I'm not the only one who's argued this, that he has actually, as the Pope, violated the idea of natural justice, and that he should not have abducted Edgardo Mortera. At the same time, actually not too soon, there was an article a couple of years ago in the journal First Things where a Dominican priest defended Pius IX, and it caused quite a controversy, and that was what precipitated my working on this. But right around that time, Mary McAleese, the former president of Ireland, defended her doctoral dissertation, the Gregorian, on this topic. Is infant baptism a violation of the religious liberty rights of infants? And so what occurred to me was like, she basically says that the Catholic Church had changed its view about baptism, and that parents that baptize their children before they reach the age of consent violate the children's rights. So it occurred to me at that point that, ironically, you had this Mary McAleese and Pius IX, both of whom hold diametrically opposed views about church and state, wind up both denying the natural justice of parents to bring up their children in a particular way. And so one of the things that I have found sort of fascinating is how, and I say this as someone, I'll confess this to you, I sometimes find myself gravitating to views because the wrong people hold the opposite views. and I think it's a character flaw. And so one of the things that helped me work this through, at least it was seeing this in the Pius IX versus Mary McAleese problem, is that it turns out, ironically, that the integralists that Peter brings up defend Pius IX, and yet at the same time, these same integralists will defend the rights of parents when it comes to these debates about school curricula in public schools. And I just think that's sort of crazy, right? They're on the one hand holding this position that the natural justice principle doesn't apply to Jewish infants in the papal states, whereas it does apply to them and their children. And so, here's the point that again, I'm confessing my secret shame here, that it's sometimes a good idea to kind of look at an argument from the vantage point of your opponent, insofar as, like, apply the same principles across the board. And to me, working on this project was really insightful, and that's all I have to say. So.
I just wanted to reply to the idea that all of these cases are free exercise cases, because that's true. And I guess what I would say is that the Supreme Court has been doing some sort of like constructive evisceration of the Establishment Clause. I mean, essentially, anytime a government, like Montana in the Espinoza case, tries to avoid giving money to a religious organization, a free exercise clause argument springs up and says, you're discriminating. So anytime you try to defend establishment, that gets framed as discriminating against free exercise. And so what I would say is, this is a way, they're not Establishment Clause rulings, but whenever you get these two clauses act together and there's an equilibrium, and if you go too far in free exercise, you risk privileging religion. If you go too far in not letting religion have things, then you risk free exercise. And I think that the Supreme Court's recent jurisprudence has gone out of whack in that way. And that's the argument I was trying to make.
So, just a few comments, because I think I went over too much, more than my colleagues here, so I should say two things.
Peter, you can use a mic to make help.
Oh. Is that works? Hello? No.
There you go.
I don't know. Well, maybe.
It's working, yes.
So, first, I want to say something that was kind of like implied, I think, by, particularly, if I may call you Dr. Ventrella, Jeffrey. There is an assumption that objective morality can only exist if it is based on God. This is kind of a version of divine command theory, that you can't have objective morality unless it is built on God. I think that was a sort of like rung through an assumption that you had, and asserted, I think, in one or two places quite explicitly. I think that's just false. In fact, I think that on a more philosophical basis, I think there is a case to be made that objective morality, if it exists, cannot be based on divine commands. But it's at least a very, very controversial issue, and there is a huge, huge literature on this question. So we can't simply assume that's the case. The second problem is that which God? Whose God are we going to rely on? It is for this reason that I went through some of the historical examples. And I find it very interesting that when there is debates between different religions, too often lives are lost. But when there is a debate, for example, in, I don't know, mathematics, whether classical mathematics or intuitionistic mathematics is the correct account of mathematical reality, nobody dies. Eric, did anyone die? No one died, no.
I feel like dying when there's math.
Yeah, I know, yeah, but that's a different experience.
You're not the only one. Many of the students feel like dying when
Yeah.
there's math too.
Or in the debate or the transition from Newtonian astronomy to Einstein's theory, I don't think anybody died. Why is that? So that's another point I want to make. I have a feeling that I empathize a lot with Dr. Beckwith, because I think that that some of the issues that are raised have such complicated and deep roots that we can't just simply take sort of, quick, this I'm here and I'm here. We are all struggling. I have very strong feelings about what is happening in this country in the last few years, extremely strong feelings, but I'm prohibited to express them because of tyrannical, I'm sorry.
I need you alive. I'm worried about your heart.
And I'm worried very much about what is the direction of this country is going. And I think that that in part that is because certain religious groups are I think changing their mission and pursue political power. But Richard challenged me on this, and he said, well, tell me, how am I supposed to express my strong views that I have? I live in this society. How are we going to do it? If not also through my political activities. And I granted to him that that is a very difficult question. So we have to worry about both. But at the same time, let us remember that the floodgates, once opened, those who open them may not be the ones that control the floods. And history shows that. Extremists take over, and then it's over. So that's all I have to say for now.
So, I think we should have something, you've heard of just war theory, right? We should have something like
Yes.
just culture war theory.
Yes.
Where
good idea.
we don't have so in just war theory, you can't have a disproportionate response. So in other words, your country's invaded, you can resist, but you can't go into another country, kill innocent people.
Yeah.
We should have like a version of that, just culture war theory, where, so if I say something on Twitter that's slightly off color, I should lose my job. Right, in other words, that's like, so, but I agree with, I think that there is this sense, I know, and I guess it just, from my own, I self-censor all the time, right? And I think one reason is that, regardless of one's political views, and we do it, and I think it's a shame. I tell my students at Baylor, some of whom disagree with me, I said, I don't care. Like, I want you to be able to express yourself. That's why I don't like the sort of rise of technology, the ability to, to sort of record everything, because as a professor, and you probably do this as well, you kind of think out loud. Mm-hmm. Right? And so, what happens when you think out loud and you, 10 minutes later, think, well, I should have said that. It should be an environment where that sort of thing is free. And I agree with you, your own sort of fears.
Yeah, and let me just be quite blunt. I am radically opposed to postmodernism, and I'm radically opposed to these extreme cancer cultures and all of these other things, even though in many cases I understand. I think I understand what leads to it. But that doesn't mean that I have a justification or I justify it. We have to distinguish between understanding the explanation for a phenomenon and the justification for it. I think there's too much of that happening, and of course, unfortunately, while postmodernism was developed on the far left, seems like now it was adopted by the right. Now we are postmodernists, alternative facts, there's no truth, whatever. So the values that we all share and are the foundation of the liberal democracy, the only system that I think is coherent, and it is designed to enhance the flourishing of all human beings, the best one that we came up with, is at stake. I think we should. Question.
You're the boss. All right, so anybody wants to come up and ask a question of either an individual panelist or the panel as a whole, feel free to approach the microphone and ask your question.
Okay, we know Kyler has a question. Come on, come on.
Riker's going to beat him as the big man in the room.
He's first, he's second.
All right. Well, I find that the question, my first question, because I'm not going to do all of them right away, but that my first question would be directed towards yourself, because the first time I came here, I think my first question was to Richard here, and it was very much against the religious point of view, and I've always been very atheist myself. But I don't want to be that guy, so I'm going to try and make this as quick as I can. This goes back to the comment on the Hobby Lobby. I remember when that happened, I was rather against Hobby Lobby at the time. I was thinking about it, I'm like, it's ridiculous. But, you know, years change you. If the government mandates that a business were to provide health care, but also provide it in such a way that clashes with their personal beliefs in a way that they find abominable, how is it the business's fault? It's the same as telling me I have to provide funding to someone so they can go buy a gun to shoot a baby. I wouldn't have any choice in this matter, just as these businesses have no choice when the government mandates them to provide the insurance, and then to how do they provide it. I think maybe the government should just have no part in the businesses providing insurance in the first place. Many of these cases don't seem to be about religion encroaching on the state, but the state encroaching on the public, and thus inevitably on the church.
There's a lot there. Good question. So there's a few things. First of all, I disagree strongly with the Supreme Court that Hobby Lobby as a corporation has free exercise rights. I believe that people have free exercise rights. I do not believe that corporations have free exercise rights. Now, the Supreme Court did not agree with me. I believe there were 4 dissenters who did. Okay. We can have an argument about what the scope of public policy should be all day long, and many, many people did not like the ACA and don't think the government should get into that business. The government did get into that business, however, and when the government gets into a business, the standard, the stricter standard, that's not the Smith test, but that the other one, the Religious Freedom Restoration Act says you cannot substantially burden somebody's religion unless you have a really, really good reason to do so, and you have no other way of accomplishing it. Okay, first of all, I do not think, and again, I'm not in tune with the Supreme Court on this one. They didn't agree with me on this one. I don't think it's a substantial burden for a corporate employer to write a check to Aetna, who then allows a doctor to prescribe an IUD to somebody. I don't think it's any of your business. I think we actually have laws that say what birth control method I use is not my employer's business. So I don't think that substantially burdens your religious beliefs, but I lost on that one. The Supreme Court did say that it was a compelling governmental interest to that family planning and the health of women was a compelling governmental interest. And so that's the test. The test isn't, can the court compel you to buy a gun and shoot a baby? It's, is there a compelling governmental interest? Is there a compelling governmental interest in you buying a gun and shooting a baby? I don't think so. Right? So these are the questions we're going to get left up to the court. Now, even though the Hobby Lobby court found that there was a compelling governmental interest, that it was really important for women's health, for the ACA to exist, and for this employer mandate to exist, they said, but there's another way of doing it, which is essentially, the government can pay for it. which is, a little bit in contravention of how conservatives usually decide cases, which is usually not to say, let the government pay for more things, okay?
Yeah.
But whatever. So I take your argument that maybe the government should get out of the business of a lot of things that it's doing.
Yeah.
That's not a religious argument, right? That's sort of a philosophical argument on the role of the government. But when the government acts, we have a Supreme Court there to decide whether what they have acted to do is something that is their business to do, whether they have warrant. And the Supreme Court did find that the Affordable Care Act was warranted under the Commerce Clause.
But
So,
I guess my last little tidbit question here is.
Sure.
So, but we're talking about the Establishment Clause and the free, within the, our Constitution, our Bill of Rights, and all that. The amendment doesn't have to do with corporations. Corporations are not government. It does not, this whole, I have all of it right here. It's all about the government. It's not about how corporations should run or how corporations should provide things or what corporations are beholden to by the law. It's about what the government is beholden to by the law.
well, the government has the right to regulate interstate commerce under the Constitution. And the right to regulate interstate commerce includes the right to tell businesses, in some cases, what they can do and what they can't do. So that's where we get to the business out of the state. Does that make sense?
Maybe.
Do you
I'm
want-
not as intelligent as I'd like to be.
No,
So,
you're very.
Who knows? Maybe I'm not
It's
getting
nothing
it.
to do with intelligence. It's just, I went to a lot of law school,
Yeah.
and I certainly don't have it right. And that's something I wanted to point out for everybody. Particularly in the Supreme Court's Establishment Clause jurisprudence, it's a disaster. I think I'm hoping we can all agree on this. The Supreme Court can't decide on a standard to save their lives. They're fighting in all of the
Yeah.
cases. Oh, what happened to the lemon test? I don't know. It's back. It's
Yeah.
gone. It's here. It's there. So these are incredibly difficult
Yeah.
issues. I think, it's incredibly hard to find a standard. That's what we're stuck with because our Constitution, I think wisely, leaves this stuff wide open.
Yeah.
But that always involves the Supreme Court making up a test over every single thing in the Constitution. I tell my students in my civil rights class, see this giant book? This giant book is Amendment 1, accept, right?
Wow.
And that's what it's all about. So I hope I explained at least my
At least,
position.
at least your point of view.
Okay,
yeah.
great.
And
So,
that has some-
can I
We
follow
gotta-
up?
We gotta follow
Yeah,
up.
I'm going to make a case for, what was the term you used about the, not the inconsistency of the Supreme Court's, or the
Disaster?
disaster, okay. I'm going to make this is kind of just, and I tell this to my students, because I say the same thing, you can't find a consistent, coherent string that connects all these cases, but I'm not sure it's always a bad thing in this sense. If you think of, let's say, American history in terms of religion as having two factions, the kind of the Enlightenment liberalism faction, which is sort of represented by Jefferson and Madison, and then the sort of providential kind of America City on the Hill faction, and neither one ever actually wins. And I think it's a good thing. I think it would be a bad thing if any one side in that debate had total victory, because it would marginalize too many citizens on either side. So I kind of like the inconsistency. And I don't know if, I think there's something that kind of keeps us honest, right? So,
I think it makes the law a little bit less predictable, though, and so.
Francis, you are a
Yeah.
paraconsistences.
what?
You are a paraconsistences.
A what?
Paraconsistent logic is where you can have contradictions.
Yeah, let me put it this way, that I think, each case brings to the table different sets of facts, and a lot of times how a justice thinks about which way to rule is going to be based on whether they find the analogy persuasive or not. And I think that has a much more to do with sort of the background beliefs of justices, what they consider plausible. So in the Hobby Lobby case, Justice Ginsburg's dissent, she uses all these counterexamples, and similar to the one you brought up about the Jehovah's Witness business owner. She reels off a bunch of them, and I think those counterexamples work if you think that the Green family's concern about a a drug that may kill pre-embryos is of no consequence at all. So I think a lot of times these analogies or illustrations, their power arises from the fact that the justice or justices, already believe what they consider to be reasonable. And so for this reason, I think that if anyone sort of is interested in winning Supreme Court cases, you have to sort of make cultural arguments and less, because the legal arguments in and of themselves, I think don't convince people. You go all the way back, let's say, to the early 20th century, there's a case called Buck versus Bell. This is the height of the eugenics movement, and there's a woman named Carrie Buck who is slated to be sterilized because her state law allows the head of public health to choose individuals who they don't want to, who they think it would be wrong to pass on their genes to the next generation. I mean, it's horrifying, right, to think that the government had that kind of power. And the Supreme Court upholds it, and there's this line by Justice Oliver Wendell Holmes where he says, 3 generations of imbeciles is enough. And you think that is the most horrible thing to say. But at that time, in 1924, everybody who was smart and insightful and hip was a eugenicist. That was like the dominant view among intellectuals. So I think that the idea that we can't underestimate the power of intellectual traditions informing justices and judges.
Just a footnote to that, I wrote a piece called Law Follows Culture Except When It Doesn't. And I highlighted the notion of Oliver Wendell Holmes and how he skirted around that, showing how the cultural impulses actually generated the legal ruling. And it was really only World War II that got people to awaken from that. A couple of thoughts, though, with respect to this Hobby Lobby issue. Hobby Lobby was known as a closely held corporation. That is to say, it's not publicly traded. And that was important to the chief's reasoning with respect to that. But I want to challenge the notion that there's no such thing as First Amendment rights for corporations. That would really cause a lot of problems in our jurisprudence. Take, for example, the First Amendment right of free speech. New York Times versus Sullivan tells us, and I think it was wrongly decided, but that's beside the point, that there is a right of a corporation, a news corporation, with respect to defending defamation claims and that sort of thing as an entity. We saw it also in the religious liberty context. Trinity Lutheran was about a church and ministry. There's a collective rights, and these are all tethered to the First Amendment, which has a right of assembly. So it's not odd to say that, oh, well, the rights are can only be, or I'd say it is odd to say the rights can only be exercised and possessed by individual persons. That's never been the case. There are collectives and there are entities in and of themselves, legal fictive entities that would be able to exercise First Amendment cases. So take that with a grain of
I just
thought.
want to respond. I acknowledge that corporations have free speech rights. My argument was that I don't think corporations have free exercise rights for a lot of the reasons that were stated in somebody's dissent in that case. I think corporations need free speech rights in order to advocate for their own positions.
What if they're religious and they have religious speech? That would be a religious right that sounds in free speech. Any churches, all the churches in this valley that are incorporated have religious rights, First Amendment religious rights. They have to have those.
But the Greens are not a church. The Greens are individual people who are saying that their business has religious rights.
Right, they control.
A church saying it has religious free exercise rights is exactly what the Free Exercise Clause is designed. I personally don't think businesses have free exercise rights, and I think people incorporate their businesses. You can't have it both ways. Either incorporation is a fiction where you don't have to have personal liability, where you get out of personal liability because you're a business, but then when you want to be an individual with free exercise rights, you can have free exercise rights. I don't think those things. And in fact, I think a lot of people were surprised that the court ruled that Hobby Lobby had that business had free exercise rights.
They're surprised that they didn't knock it down on the Commerce Clause. That's where the surprise was.
Always complicated.
This mic was set up for somebody taller than I. So
I have a question for the whole panel, because a lot of this discussion seemed to be predicated on the Abrahamic traditions, which makes sense because I've never seen a Taoist advocating that carved blocks should be illegal. But if we are going to take this view that we're getting into a time in our country where culture, religion, politics, and your individual worldview are all really muddled together. So at what point is it religious speech versus, for example, I believe that there was an example given by Professor Beckwith,
Yes.
where you said if you say that I'm doing this for religious reasons versus for non-religious reasons, it's different. So would it be wrong for a person to say not bake a cake for a gay wedding because that goes against their cultural traditions versus their religious beliefs? At what point do those two get distinguished from one another?
That's a great question. The answer is I don't know exactly. But so I think one of the difficulties, I think, with at least interpreting free exercise along the lines of the sort of query you're raising, is that if you look at sort of the deep differences that people have today on some of these cultural issues are not at all reflected, let's say, with why the free exercise clause arises in the early republic, right? So the differences between, let's say, Presbyterians, Catholics, Methodists, and Baptists are ecclesial, liturgical, issues like that, right? So you're not going to have debates about, like, what is marriage or what is the nature of humanity, things of that sort. Now, where you do have the conflicts are in these groups that arise out of the radical Reformation, like the Mennonites and to a lesser extent the Quakers, right? So that's where the sort of tension is. Today, so I think, for example, with going back to the Hobby Lobby case, so imagine it wasn't the Green family. Let's say it's the Blue family, we'll call them. And the Blue family owns a business called Diversion Doorway. Hobby Lobby, okay. And so Diversion Doorway, you know, they sell the same kind of knickknacks that Hobby Lobby does. And let's say the Blue family is atheists, but yet they hold the exact same belief about early embryos as the Green family. Can they appeal to the Religious Freedom Restoration Act? I don't think so. I mean, under RFRA, right? Now, of course, that could raise other questions of equal protection, and it will probably raise questions similar to the questions that the court had to deal with in conscientious objector cases in the 60s. Is the belief sufficiently parallel to the religious belief to, under this statute, for the court to extend that freedom? I don't know. I don't know what the answer is. I bring up an article I published a couple of years ago. I don't know quite what the answer is. I think when it comes to these deep philosophical questions about the nature of humanity, the very things that Jeff brought up, those are much more difficult to deal with as compared to sort of the kind of the Samantha Aloof case that I brought up, the Muslim headwear, and then the Masterpiece Cake Shop. There you can at least see kind of identifiable connections to those parts of life that religion seems to address in a very deep way, those involving birth, marriage, death, right? That's where, like, people talk about, when they were christened, when they were married, and whether they're going to get lost rights or some other. There's always something. Religion seems to focus in those areas of life, so it's not surprising that's where the conflicts are going to be, right? Are there secular parallels that sort of address the same deep questions? I think there are, but I'm not sure whether we have the conceptual equipment to deal with it. And some scholars have offered ways to deal with it. I'm not sure they work, so that's my agnostic answer. So.
I too think it's a really excellent question, and I think this is for another time, but we have to consider there's this notion that the state simply plays referee and that religious liberty is merely procedural, that there's no inquiry allowed as to the substantive gravis or benefit of any particular religious claim. Now, it can be dangerous to get into that. I want to admit that. But your question raises it because there's certain religions that say, you know what, to be faithful, you need to kill the infidel, you must suppress dissent, so on and so forth. Miroslav Volf points this out in his book, Flourishing. But there are other religions that say, love your neighbor, bless those who persecute you, those kinds of things. And so at one point, you have to choose what's going to be the most for human flourishing. And as it turns out historically, it is the predicates, not the ritual or the liturgies, but the philosophical predicates that came together for Christianity that promoted the flourishing of all people, dissenters, majority, minority, those sorts of things. That's an interesting question, but I think that needs to be addressed. Excuse me. Thank you. Too much mask time here.
Yeah. It's very drying. Yeah, go ahead.
So you actually brought it right back around to what I had originally wanted to respond to you about, because you started off by saying, first and foremost, that Christianity is the one that lays that groundwork. And I think it's important to recognize that that is what we hold it up to be now, maybe. Like, there were certainly times when Christianity absolutely did not believe that all were equal. There's a difference in what the teachings of Christ were versus all the teachings of Paul that came later. So are you basing it off the original Christ? Or are you basing it off of the Pauline church later? Are you basing it off of pre-civil rights era when we said that, you know, separating races was okay? And the flip side of that is that there are, which again is not to say that we should use this religion instead, but there are religions who have demonstrated a much longer history of being more egalitarian. For instance, pagan religions, where they have a goddess side, where there is equality. We see in many Native American, although also others, you know, the acceptance of additional genders and two-spirited individuals. So the idea that Christianity is the one that says we should all be equal, it doesn't. So I think to then assume that we have to or should use it as the basis for the laws that allow everyone else to have this equality, Christianity doesn't do that. I mean, even right now it's not doing it, but definitely in the past it hasn't done it. So the idea that we're using Christian basis to set laws in motion necessarily results in us discriminating against others.
Yeah, well, I appreciate the question and the perspective. I think that partly what's driving that is there was a lot of deviations in what was labeled Christianity that were defective. I mean, yeah, there were people who were professing Christians that promoted, you know, separate but equal and segregation, those kinds of things. But as a doctrinal matter, that's simply not the case. And it goes back early on. I quoted Tertullian and Lactantius, and at least I pointed them out. And what you'll find is that in its best forms, and like, again, Christianity maintains man is finite and fallen. So there's going to be deviations. There's going to be in flat-out evil. We heard some of that from Peter's remarks as well, the Torquemada Mater and Inquisition, those kinds of things. So I think that's true, but that's not a justification for absolutely getting rid of that. But it is an invitation to begin to think about that, and which has actually done that historically with all the ups and with all the downs. It is certainly true that certain, and I don't use this, I use this technically, pagan belief systems tend to be very monistic, and consequently, androgyny is the ideal. And so you're going to have implications that would pertain legally to equality and that sort of stuff. But the argument would be not that that's inherent to the pagan system, because monism makes no distinctions anyway, so it's inconsistent with itself, but rather it's aping some of the best of the Christian position. And again, I rattled off a number of authors who are not Christians who have pointed this out. The notion that our constitutional republicanism and classical liberalism, which I affirm and think is a really good political philosophy, did not come from the Enlightenment. That has been rejected by the most modern scholarship now. It actually came much earlier, and it came from the invention of the individual. In the past, there was no identity other than you were part of the polis. That's very Greek, it's very Middle Eastern. You were either part of the tribe or you were not. However, with the Christianity, what came together was you came together because of belief and confession. Whether you were rich, whether you were poor, whether you were male, whether you were female, whether you were a Jew, whether you were a Greek. That's what incubated this first notion of what is the nature of the individual. And it separated it from the polis. That was a big deal in the ancient world. So in that sense, I think we can trace it back there. So I hope that helps. There's a lot of reading to do, a lot of investigation to do. We all need to do it.
Yeah, and I mean, it does. I understand your perspective more, but I would argue that all of that still necessarily comes from that same region, because what that doesn't address is, say, Mesoamerican belief system, which was in some ways similar, in some ways supremely dissimilar to, say, the Greek and Egyptian, or even Celtic paganism, which, you know, there's definitely a history, even within pagan belief systems, that it's not androgynous, it's a duality. It's not all one, it's both. There are two sides. There's a god and a goddess. There's the sun and the moon, the yin and the yang, however you want to, there's a duality to it, but even within them, they recognize, so Baphomet has both parts. So it's not one or the other, but a continuum, okay?
I understand the perspective. I would say this, though. I think it'd be quick, you know, Os Guinness says that contrast is the mother of clarity. And so one thing you can do is start asking ethical questions. So you have the abstraction, but then if you trace down the ethical things, if I say, I love children, we should adopt those who are orphaned. Okay, because I have a religious motivation. If another person says, I love children, they're delicious, we should eat them with Chianti, hey, they're both motivated by love. Well, at some point we have to make a distinction there. That's why religious liberty is not absolute. The Moloch worshipers that believe in child sacrifice are not allowed to do that, nor should they be. There's not a strict separation. There's a concurrent jurisdiction that promotes the common good and human flourishing. And to the extent we abrogate that, I think we're dangerous. And I think my concern with the strict separation is you can let people just run nilly-willy on both sides of the track, and it can create the absence of human flourishing.
So let me just try to interject here once again. Let us notice here what is going on, right? Part of the process that I was talking about was also trying to undermine the idea that certain the political structures, certain rights that we have and so forth come from the Enlightenment. One of the things that has been fought very hard, and I've seen it happen in many of the writings, is an attack on autonomy as a value. Autonomy is self-governance. Self-governance involves reason. So what Jeffrey is doing is saying all of these values you think that came from the Enlightenment actually never came from the Enlightenment. They were there way before. Now, I think, what's your name?
Lindsay.
Lindsay?
Mm-hmm.
Lindsay raises a good question and sort of like points out a historical point here. Simply saying that all men are equal doesn't mean anything, because you can say that what I mean by man is this group. And in fact, Lindsay is right, because this is exactly what happened throughout all of history, not just with Christianity, by the way, with all the religions. Everybody's equal. By that I mean just, us. When I fought here years ago on a panel about immigration, and I said, how can Christians oppose to the immigration laws that were at that time enacted, which was not long ago, when it said in the Bible, you have to accept the foreigner, and you have to accept this, and the answer was, well, no. What is meant is not actually the foreigners. It means like the next village, but it has to be us. The problem is very simple. You can always restrict the range of the quantifier, as they call it in logic, namely, how much of humanity is included. How can you tell? I tell you how you can tell. By their actions. That's how you can tell. And look at the history of these religions and how many people were sacrificed because they were not included in the range of who are like us. So by their actions, so to tell that it came before the Enlightenment is not, I believe, a correct way of looking at history. The Enlightenment introduced a fundamental concept. And the fundamental concept was of several concepts. Number one, the well-being of human beings and what is needed for the well-being of human being depends on human reason, not on dogmas, not on dependence on some book that was somehow assumed to be written by God. Not that I diminish the Bible. I think it's very valuable. I disagree with both sides on that. Those who think there's no value in it, and those who think that every word in it is true.
Well, her point was that these things predated the Enlightenment as well. She just
There were
identified
some
a different.
elements,
She identified a different tradition. But let's flip the calculus. If we're talking about harm, we have to have a standard by which to judge harm. That's a moral question. It's not simply a subjective question. But let's talk about political entities that absolutely cabined off and suppressed religion. What harm came from the Bolshevik Revolution?
Oh, terrible.
What harm came from Mao? What harm came from Pol Pot? What, I mean, so the point
Do
is,
you know what-
religion didn't drive any of that stuff.
Listen,
The
no,
rabid
I agree with you.
secularism did.
This is not answering the point. And the reason is this. First of all, let me just point out to everybody that when we're talking about the Bolshevik Revolution and talking about communism, I lived in one. So at least I know what it is like. And I don't condone it at all. But the fact that other trends led to horrific results, it doesn't mean that we should not acknowledge the horrible results that were created by certain religious approaches. And when are those created? When you have pursuit of instruments of power. When religion grabs hold of instruments of power, then these things happen. When certain ideologies have a hold of instruments of power, especially with utopian aspirations, you get terrible things happening. So I am opposed. My view is that instruments of power are dangerous for everyone. That's why the Constitution of the United States tried to do the best they can, the framers, to divide the power so it's not held in one hand. They recognize that. And now, if we were to envision a situation in which this country, the certain religious aspirations will hold off, will grab all instruments of power, welcome to Iran.
So I want to follow up on what Peter said about reason. I'm just as much a defender of reason as the next guy, but it seems to me that reason, if just in and of itself, can't really capture every single one of our moral obligations. So let's say, for example, you hold to a sort of classical liberal view that the only obligations I have are ones that are contractual, ones that I agree with, ones that I consent to. So supposing you see me walk across the campus and two, let's say, elderly people who are homeless ask for money. And I pass by them and you make the judgment, you say, hey, Beckwith should have given them money. And then somebody, your friend says, well, maybe he gave yesterday, maybe there are reasons. But what if you discovered they were my parents? You would say to me, Beckwith's a bastard, right, for letting his parents be homeless. But I don't think but what if I said, well, but I never consented to be born, or I never agreed for them to bring me up? I mean, at some point, it seems that there are kind of inclinations that we have to do good to those closest to us that simply can't be captured by rational calculation, although I think they're reasonable. But I don't think it's something that philosophers can sit down and make arguments for.
Yeah, are you
So,
saying...
do you know what I'm getting?
Yes,
I'm not.
yes.
So
I
Yeah.
agree with you 100%. I just want to say this, I want to ask you the following question.
Sure.
Do you think that they cannot, what is the range of the cannot? Cannot in the sense of at a particular time, we can't make decisions on those things? Or you say that humanity will never be able to give reason to support certain values, moral values, which is why, if that's the case, then we have to get it somewhere, or else they are arbitrary.
So, yeah, I think that there are certain fundamental moral conclusions that we draw that are just basic. So, like the fact that we think that parents have an obligation to care for their children. I have an obligation to care for my aged parents. I don't think you can, I think at some point you just are relying on the fact that people just have this fundamental awareness that is just basic. In other words, it's the basis for all our other conclusions that we draw based on reason.
But then how you adjudicate? It's suppose that somebody has this fundamental intuition about going one way, and then somebody else says, oh, I have a completely different fundamental intuition.
Well, I think we can draw general conclusions from human experience. So, for example, let's say I say the mind is ordered towards knowing, and somebody says, yeah, but I know this guy here who's ignorant, who's having a good life. I mean, that I don't think would count against the claim that the mind is ordered towards knowing.
And it would be based on reason.
Yeah, that's right. But I think that's, in other words, what's more fundamental to the exercise of reason is an understanding of who and what are we.
I
Do you
agree
see what
with
I,
that,
so
at least in part.
I don't think we disagree entirely. I'm just trying to, I guess in my own mind, I've been thinking about my article where the, Professor or Dr. McAleese is rational to a fault, to the point where she winds up excluding parental rights. So that's my intuition. So
I would just add a footnote, brief one, that reason can be a judge or it can be a tool. I think it's properly a tool, but it's not an ultimate. It's a penultimate tool.
Go ahead.
I'll keep it
I think we're
short.
at a pause.
I'll keep it short here. Yeah. One thing I think is important to sort of add to this discussion is reason is not done in isolation, right? Like that's scholarship. Like if you're by yourself, reason invites peer review. Age of reason stuff, enlightenment, individual rights, and to Peter's point, this is setting up a structurally functionalist society in which everyone knows their roles and can interact. And I'm just reminded of the idea that the Enlightenment invites scrutiny. And it has to, by necessity of its existence. And so this becomes part of the problem when I'm teaching a class talking about Salem, and a student says, well, what if there were witches? And I'm in a conundrum because I know what the Enlightenment and what science tell, and so this becomes this point. And so to protect religion is to keep it walled off to a certain extent, because at the end of the day, religion is predicated on faith, and faith is belief without reason. And so I'm just reminded of the Diderot quote regarding the Enlightenment, that we will have the Enlightenment when the last king is strangled with the entrails of the last priest. And I think we forget how radical the Enlightenment was. We keep talking about worldviews, but the Enlightenment proffered one. Whether or not we accept it, it's up to us. But
Well, there is a radical enlightenment and there is a less radical enlightenment. Yeah. But look, I'm not denying that the Enlightenment came out of nothing. I'm just like popped out of nothing. Of course, there was a background to it. The Enlightenment came after periods of what? The pirates. Yeah, where by the way, incidentally, you raised the pagan. Yeah. So prior to the period of the Enlightenment, there was I believe 14th, 15th, 16th century, where there was more of an opening to read books from the pagan traditions and so forth and so on, which I think paved the way to. So the Enlightenment came, but it crystallized certain ideas. For example, the idea that science that came up during the Enlightenment, the methodology that science is self-correcting, that's gradually developed. That means that in principle, everything in science is up for examination. Nothing is beyond examination. the idea that science or the ultimate verdict on truth is a process, and ultimately it's the world that determines what is true, not what we decide, not what a book says, not anything.
But, is it up for examination that human beings have rights? Would that be up for examination?
Yes.
Okay.
Absolutely. And to me, the fundamental measure, not maybe the fundamental, but the fundamental measure of what are truths, particularly in these areas, which are vastly complicated, is which view that we see currently in light of our reason and the evidence we have ultimately contributes to human flourishing, of all people's flourishing, of their self-fulfillment.
See, I'm not too sure we're that far apart, because I would argue that the idea that laws ought to, in some way, be instrumental to human flourishing is itself a starting point, and you can't, why? Because you always ask the question, why is human flourishing good?
Yeah.
Well, I mean, you just sort of, it's the end of the story. So there's a point at which, we can't argue, right? But
Yeah.
I do agree with you in that regard, so.
Yeah, but I should say something very important. It is not clear that just when we say that, which conditions contribute to that.
Exactly,
And we
yeah.
can disagree on that. And in
Absolutely,
fact,
yeah.
it may be sometimes, we don't know.
Yeah.
Let's see how the world, we try this, it doesn't work, let's try something else.
Well, come on again.
Okay, sorry. And I
No,
don't
don't
mean to
apologize.
push
No one
the
else was
point.
there.
That's what I was making sure. So I wasn't standing in front of somebody. Because I'm not arguing that there should be a different religion instead of Christianity, because I think obviously that's a different flip too. I just think that the idea that morality, because I think you had also made the point, Mr. LaPoo, about objective morality coming from Christianity specifically, or even just a faith. Because I do think it doesn't necessarily have to be enshrined in reason either. I'm not saying that I have the answer, obviously. But even, and I am going to go back to paganism, because long before many, perhaps any of our currently established religions, being pagan doesn't necessarily mean that when you say you love kids, that's because they're tasty. There was a sense of stewardship. There was a sense of animus and animin. In fact, it wasn't a loss of divine. It was everything has a spark of divine. So it was almost pre-religious, even in that mentality. So I think I don't even disagree with the idea that we have something that we yearn for. We have hunger, so we eat. We have thirst. I think we have a desire for connection, so we worship. Now, whether that is necessarily a God outside of ourselves or spirit that we all come from and return to, that obviously is the difference in religious beliefs. But I think by assuming that one has the cornerstone of morality versus others can be just as harmful as assuming that there's no morality out there that can coincide with reason. Does that make sense? Am I making myself clear?
Well, you see, if you take pagan sort of periods, there were a lot of terrible things done in those cultures as well.
Yeah,
we
humans.
can't ignore these things,
No.
The goal that we have is to try to figure out how can we create a society, and then among societies, in which people can flourish and fulfill themselves the most. And I think we should agree here on the following, that once you ask, well, I don't care about flourishing, do me something.
Yeah.
At that point,
Yeah.
we are moving to a totally different territory. So we all agree on that. But what is the best thing? And that's what this is what this debate about, because this Establishment Clause, Free Exercise Clause, and all the other was an attempt by a group of people to create a new version of human society And they said what the purpose was. They said it. So does it do it? And if it, and they also said, opened up the space for improvement.
It's an experiment.
Yeah, it's an experiment.
Continuing experiment.
Somebody mentioned here the more perfect union, I think it was who mentioned it? Jeffrey mentioned more perfect, which means don't expect from humans to create a perfection, which means don't judge a country, a person, directly against an ideal, because the distance is always the same. Triangulate, judge a country at one point of time compared to another point of time, or judge one country compared to another relative to an ideal. But that doesn't mean ideals still have to be there, because we have to aspire somewhere. So I agree with you that the pagan religions contributed quite a bit. They had a different relationship, some of them at least, to Earth, for example. They highlight, we should learn from all of them, their better aspects. So I'm not against, necessarily sort of against religion, nor am I against monotheistic religions necessarily. I'm against certain approaches within those religions and their dangers, which historically were proven to be the case. Then on the philosophical level, I'm very much against personal God. And the reason is very simple, because I believe monotheism introduced an important concept, which is idolatry. Idolatry is worship of idols. And I think the best interpretation of worship of idols is self-worship. That's what idolatry is, self-worship. And I believe that when you have too close of a tangible concept of a personal God, it is very easy to slide to idolatry, which is self-worship. And I believe that the whole point, in part, and I think Christianity made a big improvement in that idea of humility. Right? Let us realize our limitations and not worship ourselves. So but the way to navigate all of this in light of human history is extremely difficult, very difficult. So.
Well, here we sit, 5 minutes after 4. I appreciate all of you that lasted with us. Thank you very much. I'd like to thank our panelists again, and thanks to all of you for coming out. So, you guys enjoy the rest of your day.
All right. So what do you teach?